May I please look?
Yes.
Lordship, I beg to mention item number 7 of today's hearing, Lordship. I'm trying for adjournment of this matter for 2 weeks.
On the
Yeah.
Lordship, I beg to mention item number 1. Lordship, conducting counsel, Mr. Disok is out of station. So, I'm praying
Yes,
for.
fix better.
Yes, Lordship.
Hmm?
Yes.
Mr. J. Karba, counsel, then counsel to the appellant submits that leading counsel, Mr. These action personally because the press for distributing after
3 weeks.
3 weeks.
Obliged. Please. My lord, I beg to mention item number 8. Today it is fixed for hearing. The leading counsel, Mr. C. Modi, is out of station, so matter may be kindly adjourned for 2 weeks.
Why these matters are listed for adjournment? All the time.
The concern has been taken from Nana PP also.
Particularly criminal appeal.
Leading counsel is out of station.
Lawyers, they have some doubt or what? Last 3 weeks, I have seen all the criminal appeals have been adjourned. Nobody is ready to argue the matter. It appears as lawyers are having some doubt.
May I please announce? I'm amicus query to this
Yes.
case. And this case has been listed for final hearing on many occasions.
But adjourned.
Another PP, they remain absent and adjourned.
You are appearing for whom?
I'm appearing for appellant.
Otherwise, I'm ready. After conviction below in this case, already the accused appellant had already suffered inside for more than 16 years. And it had been given.
It's life.
Yeah.
Let him recognize.
So, what I have got from the reports below, it is equitable. Wherein the materials which has been used as a
Is it equitable or it's liable to be acquitted?
liable to be
Acquitted.
acquitted. Liable to be if we have artifact.
Who is for this? You are appearing for whom?
I'm appearing
C.
for
Modi.
C. Modi.
My case is ready. My legal counsel. What happened to him? C. Modi.
I don't know. Maybe he has some personal difficulties, so
May Lordship. Lordship, I beg to mention item number 6. On the behalf of petitioner, Mr. Margal Omri, due to some his health issue, he could not appear today. So kindly the matter may be fixed for on Monday.
IA is for what?
Lordship, actually, I have no no idea about this matter.
I is being filed by the, and before striking off by the respondent number 5, we can check in them, I will. There is not necessary that.
And seeking impeachment of.
Support.
Well, this one is the paper.
No, can you fix for Monday, Lordship? It will be appearing on Monday. Item number 2.
For Patel disposal.
Yes. I told my learned friend that he said, "Really, who, it's fine. Sometimes we don't get in a, that's only problem. True narrow here. Gap is not there. So he can see whatever I argue from here, he can see. One lawyer very.
The task is the complete situation. What happens when he moves his head like this?
This is one. So in a very lighter vein, my lord, there was a lawyer who is no more. He's a very topmost civil lawyer. So 86, I assisted him in the case. So your lordship knows at that time, your lordship is aware. The Supreme Court judgment, Supreme Court cases, I used to make.
86,
86, 87.
86 were not born in the bar.
So 86, this way,
86 were in class 6.
class 6.
Class 6 or class 7.
A lot of difference. My lord, here,
I don't know about my brother. He was class 8 or
I was in FCC.
class 10.
My lord, SCC this way. He used to scold me. Why are you keeping it this way? Other side will see that AIR 1996.
My senior would do that.
You kindly request Tiwari sir to just keep
Move.
little level while you are arguing.
May it please your lordship, may I just.
Yes.
My lord, I'll just tell your lordship what is the case about. Without opening, then I will show the respective pages. It is about an NIT which is floated by the Power Department in respect of all the district for revamp of the electrical works which was earlier, it was done, they want to revamp. So all the districts, number, the present district is Pasigat, my lord. So a tender was floated. Now, my lord, there were two bids. One is technical bid and one is financial bid. Now, once you qualify a technical bid, then financial bid will be open. In this case, 7 bidders participated. Out of 7 bidders, my lord, 3 bidders qualified for financial bid. And accordingly, my lord, an evaluation committee was constituted in this case. And on the basis of the evaluation committee which was constituted, what they found, my lord, my rate was the lowest. And they found that this lowest is not workable in the market. So on 12th of March 2024, it was rejected. 12th of March 2024, it was rejected. I'll show that, man. I represented the matter before them and I said that look here, under the terms and condition of the NIT, there are 2 clauses, 36.1, 36.2 and 36.3. Wherever the rate is low, then you have to give a chance to the bidders to justify their rate. If it is abnormally low, my lord. Now, in this case, that was not given to me. So I wrote a representation to the authority superintendent engineer, and chief engineer also has said to superintendent engineer that you have to give a chance to them. Chance was given to us, and accordingly, my lord, it was found that it was rejected. Again, it was rejected. First, without any giving any opportunity. Second, I represented. Then, my lord, it was looked into it and it was rejected. Now, this is what your lordship will kindly see. This is about 22nd of April 2024. From there, my lord, we find that a representation was filed by my learned friend's client to the government somewhere in 18th of November 2024. This is 22nd of April 2024. 22nd of April 2024. 22nd of April 2024. Now he comes up with because he was the writ petition before the learned single judge. So he comes with an representation before the government on 18th of November 2024, 7/10/2024, and the superintendent writes to the DG Construction that we are considering the cases. And ultimately, my lord, this has been written to the secretary also, superintendent engineer, nothing they have done, and ultimately 3rd of January 2024, 3rd of January 2024, there is a letter which is written by the chief engineer, superintendent engineer, saying that we have sent the proposal, your particular.
3rd of January 2024, 25.
Which one, man?
3rd of January.
3rd of 2025. 25. Now that letter has been sent and they said that no case has been considered, it has been sent, their case has been considered, it has been sent for final approval to the government. So now suddenly the government issues a letter on 15th of January 2024, whereby 25, whereby the contract LOI was given to me, saying that I am the lowest and accordingly it should be awarded. So they were agreed by the decision taken by the government on 15th of January 2024, and this has been 25 and this has been put to challenge. So that's the facts of the case.
Just one question, like what happened to the evaluation committee?
Now,
Whether they played in role?
which one month?
That evaluation committee was there.
Yes,
Specific.
evaluation committee.
Whether they
Yes.
played any role?
No, I am telling now what has happened. Now my learned friend's client came to the learned single judge and they challenged at 15th of January 2025. Their whole case before this court was their terms and in when a pre-bid meeting was held on your lordship will kindly note that 25th of January 2024. NIT, your lordship will kindly note down and look into the NIT at page 106. Now kindly take the petition, my lord, at page 106. NIT at page 106. Your lordship's honorable justice Karnataka has gone through the petition. NIT is 17th of January.
How do you know I have gone through the petition?
No, I don't know. Your lordship, I am saying that whether your lordship has looked into it.
Other
17th of January 2024. That page 106.
106.
Yes. 106. This is the NIT. Now, your lordship will kindly see Superintendent Engineer Arunachal Place so and so for implementation of development of distribution infrastructure East Siang district under the revamp reforms based results
It's okay.
link distribution.
It's okay. It's no
Yes.
dispute. Then
Now, my lord will kindly see the standard bidding document at 111 and kindly see at page 156, 36.1, 36.2 and 36.3 at page 156. Abnormally low bids. This is three important. 36.2. In the event of identification of a potential abnormally low bid, employer, unless otherwise specified in so and so, may seek written clarification from the bidder, including a detailed price analysis of his bid price in relation to the subject matter of the contract scope, delivery schedule, allocation of risk and responsibilities, and any other requirements of the bidding document. 36.3. After evaluation of the price analysis in the event, employee determined that the bidder has failed to demonstrate his capability to perform the contract for the offered price, bid price, employer shall reject the bid. So this is what is important. It is abnormally low rate. Then, my lord, written clarification will be given. Now, my lord will kindly see
this is
It's-
part of the SPD.
SBD. Yes, right. Standard bidding document. Yes. Request for bid. Now, yes. Lordship got it, my lord.
What is called this
Standard bidding document. Yes. This is how they will, if it is abnormally low, then what is the procedure they will adopt. That's what they said in 156, my lord.
standard bidding.
Yes, standard bidding.
Bidding procedures and requirements.
I am exactly.
Okay.
36 point. Yes. Now, my lord will kindly see there is a pre-bid meeting which was held at page 261. 261 on 25th of January 2024. Now, my lord will kindly see in the pre-bid meeting, kindly see 5, serial number 5. Whether justified bid price ranges of electrical distribution system in AP for various categories as notified by GOP by memo dated 18/9/2023 should be adhered to while quoting rates in price bid. Now, if your lordship sees the clarification on the right hand side of the column, yes, it will be taken into consideration while evaluation of the price bid in consonant with ITB clause 36 of the SBP. So now 18/9/2023, if your lordship will kindly see at page 247. 18/9. See at page 247. Is the 18th of September 2023. Lordship got it?
Yes.
These are the guidelines which are issued by the state by way of memorandum. How a justified bid price ranges has to be looked into it. Now, my lord will kindly see memorandum. Upon submission of reports and recommendation by high-level technical committee, dated so and so within terms and conditions reference, as mentioned, following guidelines. Lordship will kindly mark it. Following guidelines with the terms and conditions you have laid out for adoption Department of Power with immediate effect for exercising course of tender bid process, bid evaluation, award of the contract, work of project tender scheme. So this is the guidelines, and the department should normally adopt this guideline. Now, if your lordship looks into 4, number 3, kindly see 3. 3 is important. Price variation clause. 3. To avoid misuse of the clause,
by way of wrongful invocation, thereby resulting obstruction and escalated complications in the smooth implementation of the project works, the provision of the price variation clause in the SPBT may be done away with only from bidding form may be allowed. So this is important, price variation clause. Now, if your lordship looks into 4, justified bid price ranges category wise. To weed out unrealistic, very low and excessively high and obstructive biddings, justified ranges of bid prices of materials and works as determined for respective category wise areas shall have to be adopted and adhered to it in the bid evaluation process of tenders and the contract award thereof for execution department of power as contained in the following respective annexures. So these are the category, my lord, in particular district. Now, if you see 5, this is Pasighat Electrical Division. Now, 248, kindly see next page, 248.5. Before lordship turns to next page, 248. Now see 5, validity of justified bid price ranges. The justified bid price ranges provided herein as above shall be valid for the bids of the tenders floated and processed for award during the current financial year 2023 and 24. Now my lord will kindly note down this price, justified bid ranges price will be on the basis of the current financial year 2023 and 2024. So this is important. Yes.
According to you, this will not apply.
Yes, that's subsequent.
Why pre-bid meeting basis?
Yes, but those are guidelines. This was not the terms and condition. But in the pre-bid meeting, they said yes, guidelines of 1890. I will show there are 2 statutes of the state of the government of India, where this is why they said 5 is it will only is depending on the financial year 2023-2024. So my argument, I will show it. When the price bid is open, my lord, it has to be looked into what is the market rate at that relevant time.
But that was not your pleading before the single bench. You simply said this is a guideline, it doesn't have enforcement.
No, that's what
You
I
don't say, you have never argued that this is only for 2020.
Yes, no, that's what, no, the government has, I'll show it, my lord, by an epidemic. What is the stand of the government? Stand of the government. These are only guide, my lord, that's an
Government
argument.
cannot improve their case
they
by
cannot-
filing
they
an
are not
affidavit.
improving.
What they said,
No,
what they have said.
What they said, what I'm
In
saying,
pre-bid meeting, they said this guideline will apply.
yes, the pre-bid
It
meeting,
will be based on
subsequently,
this. Yes.
subsequent government changes. Now the whole case is whether the government can, in an administrative capacity, whether they can change without affecting all the bidders. Suppose, my lord, a decision is taken by the government, it is only pick and choose and policy is in respect of one, not in respect to whole. Then yes, it is arbitrary. This is not the case, my lord. When abnormally it was low, not in Pasighat, in all the district, there was a complaint. I'll show that, my lord. How a committee was constituted. There was a complaint which was made. In respect of all the district, the abnormally low rate has been given. Now they, by a memorandum, they constituted subcommittee. They
So according to you, this memorandum will not apply.
yes,
It is only for 2020-24.
24.
That's why I'm saying we have not seen anything in your pleading that this will not apply. Simply what you have taken the ground is that this is a bare guidelines.
Yes, this is a legal point I can argue, my lord. Legal point. This is I can argue.
Okay.
Legally, this is not enforceable in the eye of law.
No,
It
that is
does
the
have
only
a-
ground you have taken.
Yes.
The grounds which you are taking now,
Yes.
which you have not taken before.
No,
the
maybe,
Supreme
my lord, but legally I can argue this matter before this court. You're right. Legally, I can argue this. It's a legal principle which has been laid down. Whether these are got any statutory force or not.
Anyway,
Yes.
We'll come to that.
Yeah.
And then next,
Now, my lord will kindly see. 263 kindly see, my lord.
initially you are thereafter, I mean, out of
7 bidders,
7 bidders
3 was qualified.
qualified,
Yes.
then what happened?
Then after qualifying 3 bidders, my lord,
Financial bid,
my financial bid was open and I was found the lowest.
lowest.
Now the authority, 12th of March 2024, if your lordship looks into it,
Yeah.
this is the rejection by them
Let's finish
at
the-
page
Let us
306.
finish the facts
Yes,
first.
that's what I mean, 306. Facts I am saying, your lordship, 306. My lord, kindly see 263 before that. I'm sorry, my lord. 263 kindly be looked into it, then I will show that. Yes. Now, kindly see 263, my lord.
Yes.
This is what on 26th of February. Lordship got it?
Yes.
Second, the following bidders have participated in tender bidding process of this package. This is 7 bidders. This is 7 bidders participated. However, out of the above,
No commercial.
yes, out of the above bidders, the following bidders could qualify in the techno-commercial part 1 bidding process 1, 2, and 3. The petitioner here is number 2, my lord. Number 2, Abilene. Now, price is the next page. If your lordship now turns to next page, price. Lordship got it? Price. Now, see that price which is quoted. Supply amount. My lord, DG Construction is my learned friend's client. Number 2 is the Abilene here, 42 crores. Techno Power is another who is not before DICO. Now, if you see the grand total, see the grand total. DG Construction is 54, 32, 54. And minus is 64, minus 54, 98, 73, 157, 44. I being the lowest. Now, lordship seen that mine is the lowest, 54. Now, if page 106 for a moment, I'll just connect that. Why it is lowest? 106. See at 106. See the 106, my lord.
How to
Estimated cost,
say- How to say that you are the
lowest. By your lordship, 64. Number 2, 54. Top is 64. Number 1 is 64. Grand total. Supply amount, election, total amount, 1%, GST, and grand total is 64. Lordship got it?
Yes.
64, 32, 54, 29, and 199. See number 2, which is the Abilene, wind power, 42, 28, 57. Now you see the grand total, 54. Lordship got it? 54? Yes. And the Techno Power is not before this court, but my rate is the lowest, 54.
Yes.
Now the value of the tender, see at 106, value of the tender, 106, the value of the tender is 6546. The value of the tender, value. If your lordship looks into for a moment, at page 106, value of the tender estimated cost has been mentioned. This is the value of the estimated cost. Now, my lord, if your lordship looks into page 306, Superintendent Engineer Road to Wind Power. With reference to your letter, ever you are request referred up with my notes. So, and so, as for biggest query and clarification, it was clearly clarified. Justified bid price ranges of electrical division dated so and so by the government of Arunachal Pradesh will be taken into consideration while evaluation of the price bid in the consonant with ITB cross 30C to SPVD. E tender so and so found your price bid 10.25 minus below the minimum justified price ranges, which is abnormally low, it was rejected accordingly. So this is the rejection. So they rejected accordingly. Madam.
And they have, as per the memorandum of 1890.
Correct, right, my lord, absolutely right.
Yes.
Now, my lord will kindly see at page 309. We written a representation to the superintendent engineer giving the justification at page 309. 309. Number 2. Clause number 2, kindly see, my lord, at page 310. 310. Clause number 2. The price quoted by us is very genuine and competitive as we have considered only 10% profit, and if you require, we can share the same with a quotation of best OEMs. It is also imperative to state that we always procure projects material in bigger scale and mass volume on regular basis. As a result, our vendors offered us very competitive price. As such, our quoted rates are workable according to prevailing market price. This is what we have stated.
Now, after rejecting your on being abnormally low,
Yes.
who was recommended? Whose bid was recommended?
No. That time, no bid was recommended that time.
No what?
No one was recommended till that time. Now, my lord will kindly see at 311. 311, third paragraph. Hope you will find our price justification aligned with your expectation. However, if you need any further clarification, that we are ready to provide the same as per your convenience schedule. The major factor for the difference between your minimum price range and our quoted price is profit margin. And if you are ready to execute the project by taking minimum profit by of 10%. So we don't think that we have any problem if we deliver the project of saving 10.25% more amount beyond your expectation. It is our out of the point to mention that we are associated with ground for more than 20 years. And once we better know how a project will execute in hinterland. This is what we inform them. Now at page 312, the chief engineer written to the superintendent engineer at 312. In terms of the NIT 36.2, a chance would be given to us. So at page 312, chief engineer wrote to superintendent engineer 14th of March 2024 and said, please give a chance because there is 36.2 says that you have to give a bidder a chance to demonstrate. But on 313, SC gives an opportunity to me at 313. He gives an opportunity to me at 313. Now there is already representation filed by me. 313 gives an opportunity. But at 314, again he rejects. 314. That is 22nd of March 2024. That is the second rejection which he makes. 3134. Kindly see on, you have quoted so and so. On the basis of the above grounds, your price bid has been rejected by the e-tender opening board. Lordship got it? So that is the second rejection. Now grounds were communicated by the superintendent engineer to chief engineer at page 315. That is 26th of April 2024. The SC has informed to the chief engineer the ground of rejection. Yes. Now, this was a position, my lord, as on 26th of April 2024. Now, lordship will kindly see what has happened thereafter. This is by way on, I'll tell your lordship thereafter. If your lordship looks now into 491, page 491. 491. This would be actually 29th of March. There is a wrong in that date because if your lordship sees 492, my learned friend government will can clarify it is 29th of March. May. Sorry, 29th of May. if you see at 492, maybe an error is there, typical error. Now, if your lordship looks into memorandum. Now, 26th of April, your lordship has seen the date, 2024. That was the last date, which it was communicated. Now, kindly see 22nd of March, before that 2024. Now, see memorandum. In the interest of transparency and adherence to procurement procedure under the revamped distribution sector scheme in the state of Arunachal Pradesh, government of Arunachal Pradesh constitutes the following committee for the project like development of distribution infrastructure under revamped based and resulted in distribution sector scheme of the Rupa package in West Kameng district. Committee may be entrusted with similar examination related to the other packages under so and so from time to time as given. The committee is composed as follows. Number one is a chief engineer, chairman. Lordship will kindly note this, chairman. Number two is the joint secretary finance member, and number three is the joint secretary law member. Those three was, this committee was constituted by way of a memorandum. Now, if you're 29th of May 2024, Mike. Now, if your lordship looks into it, re-examination process, terms and reference of the committee at page 491. The committee shall examine the justification provided by the bidders for the bids. The review shall include an analysis of the bid with respect to the subject matter, scope, delivery, schedule, allocation of risk and responsibilities, and any other relevant parameters outlined in clause 36.2 and 36.3 of the standard bidding document on so and so. Provision contained, now lordship will kindly mark this, provision contained in the manual for procurement of goods and other instruction issued by Department of Expenditure, Ministry of Finance, Government of India, from time to time on this subject shall also be added to. This is what your lordship will kindly look into it.
So nothing has been stated about the earlier memorandum.
No, now, kindly see. Now, 493 now. Now, if you see 492 last line, committee may take assistance of any technical manpower or department official as declared for the purpose. At 492, man. Now, 493 is 15th of July 2024 is a report of the subcommittee.
In your favor.
Yes, not my favor. In favor, yes, in my favor, in all, they have analyzed in all the districts. Now, my lord will kindly see. In compliance of memorandum, so and so and so. Now, 494. Report of the subcommittee. Now, lordship got it, my lord. The report presents the finding of the subcommittee constitute re-examine the justification provided by the bidders regarding low prices in the e-tender for revamped distribution. Some committee composed of officials from so and so were tasked in evaluating the feasibility and reasonableness of the rates of the bid received from 6 packages: Rupa, Itanagar, Nahalagar, Namsai, Deomali, and Pasigar. This report details the methodology, findings, recommendation based on comprehensive analysis of the justification provided by the bidders. Now, your lordship will kindly see the background. Committee is composed of so and so. Now, re-examination process kindly see on the last. The 494 on the last. The committee shall examine whether the price quoted in the bids identify the abnormally low require a justification from the relevant bidders at 494. This review shall include an analysis of the bid with respect of the subject matter, scope, delivery at 495. So, scope, delivery, schedule, allocation of risk and responsibility, and any other relevant parameters outlined in clause 36.2 and 36.3 of the standard bidding document. The provision contained in the manual for procurements of goods and other instruction issued by Department of Expenditure, Ministry of Finance, Government of India from to time on this subject shall also be adhered to. So keeping in view of 36.2 and 36.3, it is abnormally low. What the subcommittee decided that there is also a manual for procurement of goods and other instruction that will be strictly adhered to them by them. Now, we'll see what is the price at that relevant time when the financial bid was opened. Now, Lordship will look into it. The 499. Kindly see 499. This Pasighat package came later on. 499. Kindly see on 499. On 13 June, Lordship will kindly mark this, on 13 June 2024, where all the packages were before the government, before the subcommittee. This came later on. On 13 June 2024, one more package, Pasighat was ordered for re-examination of the justification provided by the bidders regarding low prices in the e-tender, e-file dated in addition to previously allocated 5 packages, bringing the total to 6 packages. Lordship got it?
So this committee,
Yeah.
all the 5 packages were already with the same committee.
Same committee, subcommittee.
Then in between the Pasighat package has been.
Absolutely, correct. Right.
What is the finding recommendation?
Yes. Now, before that, kindly see methodology, how they adopted. This is important. For methodology, market rate, then market survey.
They have based on the market, they say that there is a difference of discrepancies are wide enough. There is a difference of market value and cotton brand. Therefore, irrespective of L1, L2, L3, L4, the viability has to be fixed.
Yes, right. Correct. Now you see 506. That is a conclusion recommendation. Conclusion recommendation 5.
So this committee was constituted
Yes.
under what provision, what clause?
I'm sorry.
What is the provision for constituting a committee for
Yes.
re-evaluation once it is rejected by a tender opening committee?
Yes. Tender opening committee rejected. Then the committee, subcommittee, because there was a complaint which is made
It
by.
has to be within the provisions under the tender documents.
Yes,
Tender
this is under the standard bidding document which they have decided. Kindly see that this is what they have looked into it. Manual for procurement of goods and other instruction issued by department.
Where does it say that the subcommittee can be?
No, subcommittee does, but this is admissive decision taken by the government. So admissive decision taken by the government.
Then what's the value of the tender evaluation committee?
No, that my lord, tender evaluation committee is there, but there is no harm in forming another subcommittee by the government. Now forming. No.
Tomorrow.
Yes.
It appears in your case, on your application, on your request, this committee has been constituted again and again.
But then it is illegal. Then is
That
arbitrary.
appears to be.
That has not been done.
That is the, I think we.
No, that is not been
appears
done.
to be-
No, that is not been
Tomorrow,
done.
if the
Your lordship will
petitioner-
kindly hear me. That is not been done. That's what I am saying. This is not done.
That's why you saw us.
Sir, I am showing that.
You saw us
No, that
under
is
what provision this
No,
committee
that
has
is what
been
I'm saying.
constituted.
Probably the government has to give a, my lord will kindly say memorandum. That's what I am saying 491. Kindly see under why they have said, why this subcommittee was constituted. Kindly see 491, my lord.
That we have seen.
That's what I am reading, my lord.
So that's
What
how the government
How
can do
there
that.
is there cannot be your lordship is
Outside the
asking me.
purview of the
Your
SPD.
lordship is asking me is there any law in what manner they have? That's what your lordship is asking me.
No,
Yes,
I'm not saying
yes,
this is a tender matter.
yes.
The regulation has to be as per the, the clauses in the tender.
Yes, correct,
Terms and
Right,
conditions,
right.
the terms and conditions,
correct, my lord.
whatever guidelines, whatever.
Correct, my lord.
And there was a committee.
Yes,
After evaluation, it was found that yours is the lowest, abnormally low, therefore your bid was rejected.
correct.
Now you have approached the,
I have not
That-
approached.
you have approached.
No, I didn't approach. That's the whole case. I did not approach. I have not approached. I'll tell your lordship, because your lordship is that 18/9/2023 is the memorandum which has been issued. There is a pre-bid meeting. In the pre-bid meeting, all the bidders have agreed that yes, it will be adhered to 18/9/2023.
89.
18/9, that's a notification memorandum.
Yes, yes.
That's what your lordship's
Yes, yes.
view.
Yes.
18/9/2023 is a guideline, and that normally it is to be adopted by Department of Power.
Yeah.
Now, why the government? Now I am putting a question while giving an answer. The government, if it is on my request, this particular subcommittee was constituted, then my lord, it is arbitrary. Then your lordship will, then this has to go.
No, before that,
Yes.
admitted, I think I think, prima facie, you have approached. One, the moment your bid was rejected, you filed an application.
No, I didn't file. That's the whole. Let the government say that I have filed an application. I filed an application before the authority, superintendent engineer,
For what?
department,
For
for
what?
looking into how can you reject it?
That's why on the basis
No,
of
no,
that.
no, your lordship is misunderstanding. This is,
No, what you are trying to say is committee, there was already a committee.
there was a tender evaluation committee
Yes.
at the very first stage.
No, that day after the evaluation, your bid was rejected.
Yes.
Now, how your bid has been put in the committee, subcommittee?
No, my bid has not been put in the subcommittee. It is not my case only, it has been put. Because they want to look into it. If it is abnormally low, it is not only from package, this Pasighat is coming. It is throughout all the district, the same problem.
It was already in existence.
Yes, all of them were in existence. 29th of May.
See, when it was constituted,
Yes, it was
Committee was.
constituted 29. Kindly see.
this is 22nd March.
Yes,
Not
29.
91.
No, 29.
And that should be corrected.
29 May, my. It should be corrected 29 May.
Then when was your case was rejected?
My case was rejected in the month of March.
Which date?
My lord, first is 22nd of, yes, 22nd March 2024 is the second rejection. First rejection is 12th of March 2024.
First rejection,
12th of March 2024.
12th of March.
Yes. Then we made a representation. I said that you have to give me a chance under 36.2, 36.3. We represented the matter and we explained to them.
Yes.
Then even then they rejected on 22nd of March 2024.
That
This is what?
that is
by-
before the rejection. This committee, the subcommittee was not in existence.
Not exact, no. This subcommittee was not constituted at relevant time
Yeah.
when it was rejected. Because only rejection doesn't mean they have to send to the government for approval. Now, what has happened when this
Anyway.
my package, my lord, it is not a case that your lordship will kindly look into it.
No,
Ask the government.
suppose, see, as per this 29, this 2023 guideline,
Yes, 18/9
if
2020.
it is adhered to,
Yes.
can there be any the chances of having it re-evaluated by the subcommittee?
Look, I'll just, my lord.
Number one.
Yes.
Number two, although you have made an attempt to justify that it is the administrative decision,
Yes.
can there be a committee after committee, board after board?
No, if there is a committee, what the problem is, 18/9 2000.
And how under
Other
what provision this subcommittee has been?
there is no this provision is under the standard, that's what I am showing it, my lord. Is under a.
Clause 36.
CPW,
Clause 36.
yes, your lordship, this is under a provision. It is what they calculated is on the basis of the manual for procurements of goods and other instruction issued by department.
According to you, the bid appealing committee has not adhered to this clause 36.
They when this particular was looked into it by the subcommittee which was constituted,
After the rejection.
sir, after the rejection, not only my case was later on 13/6/2024, it was added. Prior to that, all those was a complaint was made in abnormally low.
I think issue would be whether the committee has been, can be constituted, subcommittee. Under within the purview of the tender, standard bidding documents. I mean,
No, but
Proceeding.
the question, according to me, my lord, the formulation will be 18/9/2023, there was a memorandum which has been issued. And that is only a guidelines. That's what my argument will be. It is not that it is not have got any statutory and force. Now, If the government finds that it is abnormally low rate has been given by the bidders, whether the government can again constitute a subcommittee to look into the issue that whether it is abnormally low. Then under what provision the government will look into it? Whether government bypass the 18/9/2023, bypassing 18/9/2023 and looking into the manual which is prevalent. In what manner the government will look? Now what it says, under this I will show the provision. Whatever the price bid was open on that day it will be considered on what the market rate was. Not on the date when the high power committee was constituted on 18/9/2023. 18/9/2023 and high power committee was constituted and they said these are the items and these are the minimum benchmark was given. So suppose there is 10,000, the minimum in one item and the maximum is 15,000. So 15 is a minimum. The Lordship will kindly see that's what it was given. Now suppose on the day when it was open, the financial bid was open, the market rate may vary, may go down or may come up, go down or up. The government has to look into it. So that is why the subcommittee was constituted.
May I request you to just go through this memorandum once again,
Yes,
so that it can be clarified how,
yes, yes.
how it has been considered, why it has been considered, object behind it.
And I'll tell your Lordship, 18/9/2023 was not a part of the NIT. It was only at the pre-bidding stage this particular was reintroduced.
It seems it was first, this committee was constituted to look into the matters relating to Rupa package first. But it is in addition to,
All other package, not only Rupa, in all other packages. My lord, this NIT standard bidding document, there was no provision like this memorandum of 18th of September 2023. It was only at the time of pre-bid meeting.
so
It was there.
complaints came from other packages also.
Yes.
So the subcommittee was considered.
Yes, that's what. My lord, if your lordship looks into 247. My lord, I will tell your lordship that terms and condition of bidding document 18/9/2023 was not a part of it. They bought later on because of pre-bid meeting. Now, when the pre-bid meeting was held, now they have to look into it, my lord. That was only bidder request. And they said, okay, we look into it, but keeping in consonant with 36.2 and 36 of the terms and conditions of bid document. So on the moment when the financial bid was open, my lord, financial bid was open, definitely they said that there is a complaint which has come that there are extremely low that has been given. The complaint was made. So it is not my case. It was a case uniformly it was treated to all. Well, I could have very well understood that rejection. I made an application to government. Only my case is considered. Then it is arbitrary. All the case was considered, my lord. Now, if my lord 36.1, 36.2 and 36.3, 36 is been invoked, then automatically 18/9/2023 will automatically goes, my lord. Because they will look into this manual. They will have to go to the manual. What is the current position in the market? What is the price in the market? That has to be looked into it. Not 18/9/2023, my lord. If that was not abnormally low, then the situation would have been different. If it was not abnormally low, my lord, situation would have been different. Now, why this clause 36.2 and 36.3 has been given, my lord? In to justify. Now here, if you consider 18/9/2023, the benchmark has been given in each of the items. If you see at page 249, kindly see 249. The price be 249. Already, my lord, the minimum and maximum has been given, each of the item wise.
So you are within this range.
No, what I am saying, that is below this. Now, what has happened, my lord? If this 36.2 and 36.2.3 would not have been there, I quote a rate which is below that, everybody has quoted below, my lord. Not only me, my lord, in all the packages it has quoted below. That is why the subcommittee was constituted, my lord. And moment 36.2 and 36.3 is invoked, automatically 18/9/2023 will go.
So
And they will spend.
there's a conflict.
I'm sorry, man. Yes.
18/9 and this 23 and 36, clause 36.
Yes, correct. And my lord, now I will share it straight.
But there's a conflict.
That is why the invocation of 36.2 and 36.3 comes first, because it is terms and conditional. My lord, in a pre-bid meeting,
Just
We
we
just-
would like to know how, just because, is there any on the record that the committee, with the opening committee,
yes,
has not taken into consideration of the clause 36?
which one? 36.2 and
Therefore,
36.3
the committee, how the
subcommittee.
committee was
Yes.
constituted?
This committee was constituted by way of a memorandum. That's
Under
what.
what provisions?
Yes, there cannot be any provision here because there cannot. That's 18/9 was a guideline.
There could be any sense.
No, provision is by way of, they said that it is abnormally low. So for the purpose of administration, they form a committee. And they said strictly it will be adhered to the CPW works manual and the program. I'll show it, why they have done it. Let me place it, that what was the necessity of forming a subcommittee. And if subcommittee is only in respect of me, then I don't have any case. Then it may be, this is arbitrary. How can they pick and choose me? My lord, is there any letter to show by the government that is I made an application to the subcommittee? And it is not a case. Why I will say, kindly see, my lord, at page, I'll show it how this was sent. How this was sent, government has sent it. Page 500, kindly see at 500. See at 507. Kindly see 507. See 507.
Yes,
My lord will kindly see 507.
507.
Yes. This was RTI and it was 507 at note number 15.
Yes.
See on the top, note number 15. As per the report submitted by Superintendent Engineer, Pasighat, which may be seen at so and so, and this Pasighat package may be placed before the screening committee formed by the state government by memorandum dated 29/5/2025. By whom, my lord will kindly see, chief engineer has placed this and he is a chairman. And that same chief engineer issues a letter to the superintendent engineer and say that no, you look into the respondent and send it for approval. How can the chief engineer, same who was a chairman of that committee, my lord, and he knows that this particular report, he sends it. Kindly see the next, my lord, note number 16, as suggested. Next, my note number 16, as suggested by chief engineer, which may be seen at note number 15, approval may be given for placing the Pasighat RTGS package tender to screening committee, please. So this is what, it is not my request. Page 508, kindly see now.
No, not your request in the sense you file an application, representation against your rejection.
Where I find? I
If-
did not
if-
find to the committee,
Not the committee.
to the
Yeah,
authority.
is the
concerned.
authority, chief engineer is the authority.
Yes.
Superintendent is the authority.
And why the chief engineer? Why the chief engineer has sent?
Sir, please concede something
I
which is on records.
my lord, in
It's
my,
not that they.
my lord,
Sir,
it is
sir,
not
sir,
one case
sir,
I will
sir,
fight, my
please,
lord.
Sir,
Yes.
this is not that they have just picked it up. That it appears to be abnormally low, therefore, will also re-examine by the subcommittee. It's not a case. Your case has been rejected. You file an application before the authority. And it was considered and placed before the subcommittee.
I think
It's not that simply.
I could not make your lordship, I think I could not make your lordship make understand this particular, I could not, I think.
No,
My
what
lord-
I'm saying is,
Yes,
you have filed a representation against your rejection
yes, right,
before the chief engineer, superintendent.
correct, right,
It was rejected.
Right.
Second time.
yes, correct.
Again, you filed it.
No, but after rejection second time, I did not file anything, my lord. Then these packages, then the chief engineer, I did not file any representation to anyone. After second time, I rejected. Now, when they found the other packages also, they were abnormally low. Now, by virtue of this note,
No.
at 507, it was sent. The Pasigat package was sent of his own by the chief engineer. My lord, am I clear?
After the rejection.
Yes, all it is, he sends it.
Let us see the rejection.
Yes,
Your representation, how it, when it was rejected, that will be crucial.
now
Well, clearly
36.1, your lordship rejection, your lordship will find at page 306, my. Second. First rejection, kindly see, my lord. This is 12th of March. Lordship got it, my lord.
Yes,
12th of March.
yes.
With reference first rejection, my lord, your lordship will note
It
down.
was rejected accordingly.
Yes, correct, right. Now, my lord, second rejection, your lordship will kindly see second rejection is at page 314. 22nd of March. Lordship got it. 22nd of March 2024 at 314.
314.
Lordship got it. Kindly see on the last slide. Last. On the basis of the above ground, your price bid is rejected by the e-tender opening board at page 314.
Yes.
Now, committee was formed in 29th of May 2024, Mike. And 15th of July is the report. And before that, this Pasigat package was also sent. 13th of June by the same chief engineer who rejected. And representation is based on at page 156, 36.2 and 36.3 of the standard bidding document. Because it is, they said it's abnormally low, you will not match with the market rate. Is explained. I can match with the market rate. And the same chief engineer sends it to the high power committee, my lord, to the committee, subcommittee, my lord, on 13th of June 2024. March it is rejected. Second rejection is 22nd of March. 29 May is a committee. Report is 15th of July
26
2024.
2024 letter.
Yes.
That has started the whole process of re-examination.
Yes. 26th. And thereafter, my lord, waited. And this subcommittee report also has to send to the government. And ultimately,
Now,
government.
see, page 307,
307.
this is 306, your
307.
request was rejected,
Yes, right.
12 March. Then
Then,
you filed an application again
yes, 12th of March, I filed the application. Same date I filed.
for another opportunity.
Yes, because they
Then-
did not give any opportunity per stage.
Then
Then the justification only price. Now then, my lord, the again rejection. My lord, I have written to them, given detailed explanation. That is page.
So 14th we have written to them. after the first rejection.
Yeah.
Is that
Yes.
then
12, on the same day, I have made a repetition to them. At page 309. 309. And at page 312, the chief engineer writes to superintendent engineer saying that please give a chance to justify his rate.
Yes.
Now, according to that, my lord, SC gives opportunity to appellant at 313. 313. Under clause, kindly see the clause. Further, and clause 36.1, 313 on the last two lines, 36.1 and 36.2. Further, you may refer clause so and so. Now at page 314, this is a rejection. At 314 at 22nd of March 2024.
is the second rejection?
The second rejection. Second rejection.
Then as per your submission, we have not written anything to them after.
No, I have not written anything to them. Because it appears, my lord, from the at page 506. See 506. 506, chief engineer has sent it. At 506. 507.
That is the whole problem.
Yes, 507.
312. Chief engineer wants that your case has to be considered.
Not my. Where?
Reconsider. 3112.
31.
12.
Can I see this? 1 second, man.
To the superintendent engineers.
Yes. Yes.
Come to while reviewing the document, it has come to our attention to the form copying abnormal law amounts. Measures which so and so has not been afforded an opportunity to
Yes, correct.
justify the law constraints and so and so, so and so. Then ultimately, at second time, page
They-
314,
Correct.
rejected superintendent
Yeah,
engineer.
you're right. Your
The
lordship
chief
is
engineer wants that it should not be rejected, it has to be considered. Again, so there was a committee,
yes.
other packages are being
Chief
taken.
engineer doesn't want.
Therefore, I'm not saying that you cannot straight away say that you have not applied for to be placed before the subcommittee or something like that. You are agreed that I should also be considered.
To whom,
I mean,
my lord? Not
Superintendent,
This is not the sub.
how you will be
No, it's
direct?
not a subcommittee.
I was not saying that subcommittee,
Yes.
authority you have applied,
Yes, I have applied.
somebody has placed it.
Yes, they rejected it. They-
On your application only, not to place particularly before the subcommittee.
No, all, not that. My lord, entire Pasighat package has been sent.
Sir, let us be very fair.
No, I am fair, my lord. My lord will not say that I am not fair.
Whether-
This is 40 years of
I am
practice.
not
I'm
saying,
very
I am
fair.
not saying, sir, sorry,
No,
I am not saying that you are not saying.
I'm fair, my lord. That's why I'm saying.
I am not saying that you are not fair.
Yeah.
I said, let us be fair.
No, your lordship may
See,
reject my
appellant
content.
has approached after the rejection
Yes,
and the superintendent engineer has rejected it again
Yes.
and again. Chief engineer wants to get it done. Maybe he's correct. So what I am trying to
yes.
say is, in my, I don't know, my brother, my primary view is, since you are agreed by the rejection of being abnormally low in the price bid, and as per clause 36, you want that it should be reconsidered. It should be given a chance.
Yes.
Superintendent engineer has rejected it.
Correct. Right.
Now this has been placed. Can we not say that you have hands your up and it was just taken by the government itself? It's not that.
No. What I'm saying, with great respect to what lordship is saying, that your lordship is right. That I applied.
Yeah.
12 of, your lordship is right. I agree
Up
to
to
it.
that, I'm not saying that you have
No, your
asked for
lordship is
placing
right.
it before
No, I'm sorry, my lord. I'm not. No, your lordship. I am not saying.
Subcommittee.
No, 12
I'm
of
not saying-
no, your lordship is absolutely right. Your lordship is absolutely right. 12 of March 2024, my first rejection.
Yeah.
Your lordship is right. Then I applied. I said, you give me a chance. Then the chief engineer has written to superintendent engineer saying that you please give a chance because there is a provision under 36.2 and 36.3. Accordingly, chance was given. And they have looked into it and rejected. Your lordship is absolutely correct on these dates. Absolutely no problem, my lord, on this date. Now the question which your lordship is asking, under what authority this subcommittee has been constituted?
Yes.
This is what your lordship is asking
Yes.
me. Under what authority?
Yes.
Whether they can bypass 18/9/2023 and form a committee. I think that's what your lordship is asking me.
Bypass not only that 18/9/23.
Yes,
But the decision of the
this subcommittee,
evaluation committee,
this
tender evaluation committee.
tender ability,
In
yes.
case if the authority or the
Yes.
government
yes,
or the employer or the, for that matter, the government or the competent authority
yes,
finds that it has not been properly evaluated,
yes,
the government has the authority or power under which power to relook into it, constitute a committee, re-evaluate it, something like that.
Not
that,
the-
that we would like to.
yes, yes.
What is that clauses?
My lord, that clauses, very frankly, I'm saying that clauses has not been mentioned in the memorandum. Not been mentioned. What they said, my lord, in the memorandum, a memorandum has been issued on later on. That later this is issued
By the
somewhere,
government?
yes, by the government. And they say that whenever it will be adhered strictly in consonant with 36.2 and 36.3, looking into not 18/9/2023. Let me make it very clear to your lordship. Your lordship is right. 89. Looking into the standard, into the CPW manual, they have mentioned and standard bidding document. They will look into this provision. But 18/9/2023 in the committee, it was not mentioned. Let me make a point.
Having considered that in other packages,
Yes,
there are also discrepancies and anomalies or the complaint,
yes,
right?
yes. There are, because that is what the government is saying, my lord.
Initially, it were one package.
There were Rupa
West-
package.
West
Yes,
coming.
yes,
Rupa
Rupa
package.
package. There were number of packages.
Then it was all the other. packages.
Yes, correct,
There
correct.
was a complaint.
Yes.
They were to- was
But
needed.
my lord,
One
is-
another-
yes, correct,
The
correct.
last thing your.
Yeah, right. But your lord,
Last
your,
thing the
yeah,
Patika
correct.
did.
But your lordship is right. But there is no mention. Your lordship is right. There is no mention of 18/9/2023 of the subcommittee. Subcommittee, my lord, your lordship is asking a very relevant. Why there is under what provision? My lord will kindly see. My lord, can I just take your lordship's indulgence to the affidavit that has been filed by the government? 396, my lord. For a
That's
moment,
what, sir.
396, my.
Yes, sir. Rest facts, it's okay, we've understood. Where, I mean, we would like to have a pointed query that in this tender,
Yes,
what is the power and authority of the government?
yes.
The approval authority.
Yeah.
Is there any provision
Yes.
or the clauses which empowers the government to re-examine or relook?
It's not there. No, it's not there. Let us put it point
But
blank.
ultimately, it has to be approved by the government.
Yes, it is not there.
No, is it
It has to be approved by the government. Right.
clauses there?
Yeah.
Clauses are there.
Yes, no, it is there itself.
The
No, no.
approving authority is the government.
Yes, ultimately the letter which is sent by engineer or whoever, they send, we will send it to government for approval.
So that's what I'm saying.
Yes, ultimately
What
government,
is the
government approval.
what is the provision? We just wanted to know.
Your lordship is right.
Because we come across in some tender matters
Yes,
that there's a clear provision. After the evaluation, it has to be sent to the
The government
competent
for approval.
authority. That is maybe the government.
for approval.
If they find that there is certain discrepancies, they have the power to re-examine and re-evaluate the tender. That if there is anything,
Yes, your lordship is right.
we just would like to know that.
But if you see a 317 page, 317, that is letter, your lordship is right. The approval from the government is still awaited. So there has to be an approval for the government.
It's okay. We just wanted to know.
No, that is
I
right.
know that it has to be, but
Yes.
we just wanted to know the particular clauses
Hmm.
in the SPD.
Yes.
Is there any
Yes.
way they-
Yes, yes. Yes.
In terms of the tender evaluation committee, where is that?
Terms of evaluation.
Tender evaluation.
Once the One 157. 157. 157. I'm thankful to my learned friend. Award of the contract.
$39. 157.
157.
38.
Page, my lord.
It gives little scope. Page 157. Having compared the aggregated cost price bids as per HGB 34 and explained the employer shall determine the most advantageous bid.
Page 137.
One bid. The
What?
most advantageous is the bid of the bid also. Let's specify requirement as per section.
Terms and condition. Sometimes I am just checking it. There is no like evaluation committee, forming of an evaluation committee.
Yeah, that's what I was.
It is
thinking,
whether
there was
it's
nothing there.
I- After evaluation, they say, after evaluation. 130, 36.3 after evaluation of the company. 136. So whether evaluation committee is on the basis of terms and condition or not, whether it has not been laid down.
So where is the constitutional evaluation committee? Is there any provision? Is there any notification which has been given?
So who held this pre-bid meeting? Pre-bid meeting is page is 261. Superintendent of engineer. Plus 250, 61.
Does it mean that there was no committee at all which evaluated those bids?
No, this is prior to this pre-bid meeting. Evaluation committee will come later on. Minutes of pre-bidding was
That's fine.
initial.
Sometimes it happens that like committee is formed earlier, then committee heads on this thing. So there is no evaluation committee.
I have, subject to my learned friend can show it. Whether there is any evaluation committee has been in personal terms and condition, there is no evaluation. There is no.
Is it fact that there is no evaluation committee at all? Yes, there is evaluation committee.
No, but
It talks about employer only.
So employer is the superintendent engineer. Yes.
normally, in this type of contract, normally government has an in-house evaluation committee. Because somebody has to evaluate it. So they form a terms
No,
and
we just wanted to know whether there is a provision for constitution of evaluation committee.
under the terms and condition of the NIT. That's your lordship wanted to know.
Because opening an evaluation is only by it talks about the employer only. There may not be a bar to constitute a committee.
Yeah, there will not be a bar. But terms and conditions,
appears to have,
your lordship, there normally
because
there
it
may
talks
be
about the employers only.
employees.
Employer.
But there may not be a bar to constitute a committee. And secondly, my lord, if your
That's all.
lordship, no, if your lordship looks into the
Anything else?
affidavit of the government at page 401, this is important, 401, that I was giving a reply of 18.9, which you said, your lordship, that how the government decides by subcommittee which they have formed and in what manner they have looked into it. This is at page 401.
Yes. 401.
401, the affidavit filed by the government. We start from 395, 397. That is 401 second paragraph. The communication from respondent number 2 was made in accordance with the provision of clause 36.2. Lordship got it, man. At page 401. 36.2 and 36.3 of the standard meeting document of RDGS and para 7.57 of manual for procurement of goods 2007
70, which governs the evaluation of abnormally low bid. As per clause 36.2 of the standard bidding document, if a bid appears abnormally low, the bidder is required to furnish a justification to demonstrate the feasibility of executing the contract at the quoted price. In compliance with the provision, the respondent of line was afforded an opportunity to provide just justification. Now, if your lordship looks at 403, paragraph 9, that with regard to the statement made in para 13 of the writ petition, the answering respondent humbly states, beg to submit that petitioner claimed the bid was forwarded to consideration and approval by the competent authority on 26/2/2024 does not imply any entitlement to contract award. The evaluation of the price bid was conducted in accordance with standard bidding document of RDSS, and the recommendation made by tender evaluation authorities was based on a structured assessment of bid responsiveness, cost effectiveness, and financial feasibility. As per the computer auto-generated so and so. Now 404, with the petitioner bid, while the petitioner bid was included in list of evaluated bidders, the final selection was based on thorough re-evaluation by the re-evaluation committee constituted by the government on 29th of May 2024. The committee review in compliance with clause 36.2 and 36.3 of the SPD of RDSS and para 7.57 of the Manual for Procurements of Goods 2017 identified Messrs. Wind Power Infra Guwahati as the most competitive and responsive bidder. The government approved this recommendation on 8th of January 2025, and letter of intent was issued on 15th of January 2025. Now, if your lordship looks into it, now the
Initially, one techno power enterprises was recommended.
yes,
You said there was no recommendation.
these are
Para 7.
yes,
Paragraph 7,
these are auto-generated. That's it, auto-generated
no,
initially.
no, but then why recommendation to this techno power enterprises for award of the tender dispatch so and so what it being done?
As per the these are all auto-generated price bid.
Appears to be both the superintendent engineer and the chief engineer has a different, they are not
And my lord, you know,
in coordination.
and the same,
Different idea,
the same chief engineer,
it appears
Yeah.
from the record.
minus same chief
Both
engineer.
the chief engineer and the superintendent
Now,
engineer.
chief engineer was the same person, my lord. In somewhere in November, he sends it and says superintendent engineer send it for recommendation to the government. But same chief engineer knew because of 13th of June 2024 at 506, he sends this package to the government, to the subcommittee, and he approves. So what he could have done, suppose implementation DFI said, no, we can't do anything because we have already sent this package also along with other packages. So you please wait till the report is being furnished. He did not do it. So that's what you're showing, that there is maybe a miscommunication between these two.
Miscommunication, something deliberate
But
communication.
what my submission is that now your lordship looks into which they relied on the
So then
now kindly see one, my lord. This is what they have done in evaluating it.
there are
Standard operating procedure for CPW work, which this subcommittee, my lord, relied. See SOP number 553. How you will find photo? Now kindly see this minor, I'll just show your lordships.
They talks about the para 7.5 of the
Yes.
manual for procurements of.
Yes, yes,
Where
yes,
it is?
yes,
You have not given para point,
yes.
para 7. Which is-
Now, 456. See 501, on what basis they have considered it will now, will be consonant with 501, kindly see 501 of the report, my lord, 501 for a moment, and keep that in one hand, my lord, 501. Yes, 501, my lord, 501, procurement of manual, kindly see, 501, procurement of manual, lordship got it, 501. Other document considered, kindly see other document. Departmental estimate was taken into account at 501. 501.
It's a report.
Yes, report. What on what basis they have considered? Kindly see 501.
Yes.
501. Departmental estimate. The departmental estimate cost was taken into account for analysis purposes for those items which are outside the list of identified items specified annexure and whose market rate could not be available. Now, procurement manual. Standard bidding document RDS clause 36.2 available at annexure so and so. B. Standard operating procedure SOP number 5/3 of the CPW work manual available at annexure so and so. Manual of procurement of goods 2017 available at so and so. So these are the considerations which they have looked into. Now, if your lordship looks into these 465, it is mentioned in the paper book itself, 465. 465, kindly see my note. 465. Consideration of abnormally low bid at page 465, that is 7.57. 7.57 below. Abnormally low bid is one in which the bid price in combination with other elements of the bid appears so low that it raises material concern as to the capability of the bidder. Lordship got it? At page 465, down below 7.57. Consideration of abnormally low bids. As abnormally low bid is one in which the bid price in combination with other elements of the bid appears so low that it raises material concern as to the capability of the bidder to perform the contract on the offered price. Procuring entity may in such case seek written clarification from the bidder, including detailed price analysis of his bid price in relation to scope, schedule, allocation of risk and responsibility, any other requirement of the bid document if after evaluating the price analysis, procuring entity determines that the bidder has substantially failed to demonstrate his capability to deliver the contract at the offered price. The procuring entity may reject the bid proposal. However, it would
This
not.
the annexure part of this the affidavit.
Which one?
No, page 465 is a part of the affidavit of the government.
Yes. Yes. Now, however, it would not be available to fix a note which would automatically be considered as abnormally low bid. Due care should be taken while formulating the specification at the time. Now, let me kindly see my note. Due care should be taken by formulating the specification at the time of preparation of bid document so as to safeguard against the submission of abnormally low bid from the bidder. Now, if your lordship looks into it, CPWD manual. Now, kindly see the manual. Cross 5.16, kindly see. Cross 5.16. Lordship got it? CPWD manual. This is what they have considered by the subcommittee. Clause 5.16, justification of tenders. My lord has got this. Yes, justification of tenders should be prepared by engineering charged with assistance of so and so. The justification, pre-line, should be invariably be prepared before the date of opening of the financial bid. Procedure on justification of tender is given in SOP 5/3. Got it, my. And that is 5.1.6. Justification of tenders. No, your lordship is this CPW work manual.
Yes.
Yes, kindly see 5.16. 5.16. Now, last three lines, justification should be invariably be prepared before the date of opening of financial bid. Procedure on justification of tender is given in SOP 5/3. Now, if your lordship looks into it. Now see the SOP, my lord. SOP 5/3. See the SOP 5/3. Justification of tenders. SOP. This is what they, my lord, have done it. Kindly see. Justification 1. Just top, lordship got it? SOP. Justification of tender. That is, my lord, the standard operating procedure.
It's okay, sir. Let us come to the judgment
Yes,
under appeal. What's wrong?
yes.
Correct.
Judgment your lordship will find at page 36. Page 36.
Can they refer to the internal page?
Yes, I'll refer to the internal date. What is the finding? Your lordship wants the finding?
Yes.
Yes. There are,
So, according to you, why this techno power enterprise was declared as L1?
yes.
Why?
No,
On what basis?
in initial, in computer ready, it was shown as number 1. In computer,
To
ready.
techno power.
Yes, in the computer ready, this is auto generated. Auto generated, my
But
lord. He
what-
is not number 1.
No,
If you
what?
see-
No, what you have shown
Yes.
in that thing
Comparative
report,
price.
it's comparative state.
Yeah, this is number. His rate is much more higher than the us.
Higher.
61. Yes.
So
So-
therefore, he's L1.
He is not L1. I am L1 because I'm the lowest.
That's why I'm saying why he's been.
No,
shown
that
as-
is why computer generated. There was something. These are all computer generated.
Otherwise, L1 is you,
Yes. L1 is my.
lowest.
Yes.
Why? No. It's because just because of the auto
Yes.
generated
Yes.
that
Yes.
the superintendent engineering has recommended
Yes.
being L1
Yes.
to techno power enterprise.
Yes. Yes. In the affidavit in 403, it has been mentioned by the government.
Yeah, that we have seen.
Yes.
They have clarified it,
Yes.
sort of some kind of clarification, though not exactly.
Now, my lord will kindly see at page 49, para 27,
Internal page.
internal page 16.
16.
Yes,
Yes.
para 27. The issue in, lordship got it?
Yes.
The issue revolves around the decision-making process in the concerned NIT dated 17/1/2024. Before going to the said aspect, it is required to make a determination on the aspect of memorandum dated 18/9/2023 and its binding effect on the NIT in question. Aforesaid memorandum dated 18/9/2023 was issued, whereby guidelines were laid down, which have been followed in the power department in matters of tender, bid process, evaluation, and award of the contract. The said memorandum has in clear terms laid down laid down the concept of justified bid. The period in which the memorandum would have been effect and a division connecting the present NIT, namely Pasighat, are specifically mentioned in the said memorandum. The issue whether the memorandum will have any binding effect would get answered by the decision conveyed in the pre-bid meeting held on 25/1/2024, in which it was clearly reflected the said memorandum would be adhered to. For ready reference, the relevant part of the pre-bid meeting is extracted so and so. I will not trouble because already it has been read. 28. It is not in dispute that out of 7 numbers of bidders, 3 bidders were found to be technically responsive, which included the petitioner. Response number 9 and 1, Messrs. Technopower Enterprises, and in the financial bid, the bid of Messrs. Technopower Enterprises was declared L1. It is, however, to be noted by the said decision dated 21/2/2024, the bid of response 99 were rejected as being abnormally low. The order of rejection was duly conveyed to the response number 9 on 12/3/2024, whereafter on 14/3/2024, response 9 was given a further opportunity to justify his abnormally low bid. The response number 9 has in fact tried to justify his abnormally low bid by the response dated 15/3/2024, which was considered by department by letter dated 22/3/2024. Justification was rejected by e-tender opening board. It is not in dispute. None of the decision dated 21/2/2024 for rejecting of the bid or response number 9 to be abnormally low. Communication dated 12/3/2024 and 22/3/2024 whereby justification itself was rejected are subject matter of any challenge in any court of law. I am just pausing for a moment. I am just giving a reply. Because once it is rejected, doesn't mean that I have come to the court. Ultimately, it has to be sent to the government for final approval. Now, once an approval is given, then we come to the court that how an approval is being given. It is not a case, then once it is rejected, then rejection doesn't mean then contract will be awarded to me. Rejection doesn't mean, because ultimate final authority is the government. They will send it to government. Government will look into it.
But facts remains that these rejection orders
Was never
have
put
not
to
been put to
put to
challenge.
challenge.
It's not a
But
subject
here
matter
is
of
not a
challenge.
part of a major
Anyway,
challenge.
yeah.
This is one. Now 50, next page, man. It is category case of the petitioner that from 22/3/2014 to January 2025, there was complete silence from department and the petitioner was even not even aware of formation of any subcommittee.
Why 2014?
I'm sorry.
Why 2014?
This is not
Should be
2014.
2024.
It is wrong, 2024. Not 24. And there was complete silence from department and the petitioner not even aware of formation of any subcommittee. Aforesaid contention gets fortified by the aspect that the petitioner had submitted representation on 21/11/2024 for revaluation of the financial bid, inasmuch as no action was taken by L1 bidder. Messrs. Techno Power Enterprise for allotment of the work and sufficient time has elapsed. It is also on record that the representation of the petitioner was duly considered and the chief engineer White Communication dated 26/11/2024 had also directed the superintendent engineer to make a comprehensive re-evaluation of the bid of the petitioner. What therefore emerges is also very crucial to the instant case. After such revaluation by tender opening committee, White Communication dated 3/1/2025 has indeed made its recommendation in favor of the petitioner by coming to conclusion bid of the petitioner was found to be least deviated from the standard rate. For ready reference, the relevant extract is quoted here as below. Now, this all the rates. Now, kindly see at para 30. It was therefore the report of the subcommittee was in public domain on 12/1/2025, which was immediately followed by issuance of letter of intent on 15/1/2015. As observed above, when this writ petition was filed, an interim order was passed, which is continuing as on date. The subcommittee initially appears to be for the other packages and not for Pasighat, which was made a part of subcommittee at a subsequent stage. Be that as it may, it revealed that the subcommittee had deputed one assistant engineer electrical to Kolkata to make a market survey, and thereafter, based on such market survey, decision has been taken. Bid of response number 9 would still be justified. Learned Standing Council Department was fairly submit neither the NIT nor the tender document provides for constitution of any subcommittee, and the same has only been done in the interest of public. When public interest is one of the crucial factors, action of the department has to be strictly in accordance with law. As has been laid down in Catena of Judicial Procedure that in contractual matter, examination of decision has to be done not from the perspective whether decision is sound, but whether decision is lawful, without even going at this stage to the aspect of any malafide or bias of the authority. There is a legal malice inasmuch as such formation of subcommittee is not envisaged by any law or the tender document. Law does not emphasize or provide a department to keep on during evaluation after evaluation until certain desired results are achieved. This court also finds sufficient force in the submission made on behalf of the petitioner that even the recommendation of subcommittee were discriminatory in nature. He has clearly submitted, at least for the package of Rupa, Itanagar and Alagar, though the subcommittee has accepted abnormally low bid, LOI was not given to different bidder. Court has also verified and found that Pasigat package was made a part of subcommittee at a subsequent stage. However, without going into that aspect of the matter, considering the Pasigat was also one of the matters within the examination of the subcommittee, the very formation of the subcommittee clearly appears to be not in accordance with law. What also increased this court is that after the rejection of the attempt of the response number 9 to justify its bid by the e-tender opening board, there was no challenge, and therefore there was no occasion at all to reopen the matter. As already indicated above, no provision or law or the tender document has been able to show under which the subcommittee has been formed. Which Lordship has put that particular question under what provision the subcommittee has been formed. In this communication dated 26/4/2024, Superintendent wrote to Chief Minister citing the reason for rejection. So this has been, my lord, they looked into it. Now 37. So far, reliance of the response number 9 case upon BB Enterprise is concerned, though there is no dispute in the proposition that conclusion arrived by a specialized committee are not to be interfered with those committee has special knowledge in the instant case. This court has noted in that case, committee was a part office memorandum and therefore no interference was made. However, in the instant case, there was no legal backing for constitutional subcommittee to seek justification coupled with the operation of memorandum dated 18/9/2023, and therefore the facts are totally distinguishable from facts in hand. As regards the submission advance on behalf of response number 9, that certain other packages are also involved. So any interference would also affect those packages. This court is unable to accept the said contention. This court sees with the matter at the present work concerning the Pasigat package, whereas the decision taken is impugned, and it is in the context of that decision that this court is educating the matter and has come to the conclusion. In the context of the aforesaid discussion, facts are narrated. The court is opinion that the case of interference is made out according to the impugned letter of intent preceded by a decision to allot the work in favor of response number 9 by department. Subcommittee will set aside and quash matter is remanded back to allot to work the eligible bidder strictly according to law. So now this has been agreed and has been put to each other. Now there are judgment which has been cited by the before the learned single judge.
Is there any discussion on clause 36 point?
36.2, 36 point. That is not there. It is an argument. What they discussed, they cited certain judgment of this court, and that is why they pointed out.
Basically, the court issue decided was whether the subcommittee was valid or not, whether it was properly considered or not. Only that issue that
Yes.
signal was from.
Yes. But 18/9/2023 was also not a part of the tender. It was only brought in the pre-bid meeting that was held on 25th of January 2024.
No, which
It is-
It was not, I mean, that.
That was a guideline which was issued. Guidelines. But when the question of the day of opening of the financial bid was concerned, that day it was open, Then they said that it was lot of anomalies, lot of complaint was there. It was abnormally low in most of the division. That is why a subcommittee was constituted, and they still
No issue has been raised by anybody at that point of time. About that.
pre-bid meeting, nobody has
Done.
raised that. 18/9/2023.
So we right there,
I'm sorry.
as far as that thing is concerned.
Now whether on that basis of 18/9/2023, whether it is a guideline which has been issued or whether government can override that guidelines by way of an administrative decision to see that this particular fair and transparent manner, whether in the public interest, whether another subcommittee can be constituted. And it is only if it is formed and it is looked into it in the public interest and not singling out, but taking as a whole, that nobody should be affected, then that has to be looked into it. Now, suppose somebody, it is for not for all, then yes, that decision which has been taken by the government, by a subcommittee, by picking up an individual, that will be, I think, will be an arbitrariness. Here, in respect of all the packages, that particular decision was taken. That we will look into standard meeting document 36.2, 30.3. If 36.2 and 36.3, again, I'll reiterate that argument. 36.2 and 36.3, it will be taken into consideration as part of the terms and conditions of the NIT. My lord, 18/9/2023 will not come away. It is only at the time when financial bid will be opened. At that time, what was the market rate?
No, they say that it will be taken into consideration while evaluation of the price bids in consonant with the clause 36.
Yes.
How you
Now 36. Now yes, your lordship is right.
how you apply
Yes.
this
36.
9/20/23
Yes.
in consonance with
36.2 and 36.3. Now 36.2 is suppose you quote a rate abnormally low, then a chance has to be given to a bidder to demonstrate that what is the rate you have quoted. Now, if your lordship looks into the memorandum of 18/9/2023, item-wise rate has been given. Item-wise rate. Now, there is a benchmark which is given. Minimum which has been quoted in one of the item may be 10,000. Maximum may be 15,000. Am I clear to your lordship? One of the item. Now, suppose I quote a rate less than 11,000. Suppose I get 8,000, but the benchmark is given 11,000. Then how one will decide at the time when the financial bid will open? Whether 2018/9/2023, at that relevant time when the market rate, where they have
okay,
calculated.
that we have understood.
Ah.
What I am trying to understand is how you apply this
That is why
18/9/23
you cannot,
in
you,
consonance with
30.
clause
Now
36
that my argument will be, you cannot apply 18/9/2023 when
in
you take
consonance with 36.
36.2 and 30. Moment you calculate 36.
You will catch it.
Yeah,
Why you have
36.2.
said, why you have said so?
No, 36.2 and 36.3. My lord, when you look into it, then you have to look into this provision of standard bidding document and this whatever was relevant. Not 18/9/2023. As per the CPW manual, you have to look into it.
I think,
I-
sir, we have heard you enough.
I'm
Kindly
deeply-
formulate your submission.
I am deeply obliged for hearing such a patient hearing. I'll show one judgment of this appellate court judgment, one judgment of state of Arunachal. If your lordship just allows me to put it.
It's okay, just give the judgment.
Yes, correct.
In any case, we will not be dictating the judgment in the open court.
Para
Let us be
49,
Clear.
para 49,
Let us not read it again.
para 49.
Yes.
When the government can change the policy decision, see 49. This is Writ Appeal 17. Parties name is Rural Information Corporation.
You know,
See 49. 49.
Don't find the process.
We also do not find that the process adopted or decision made by authorities malafide intent to favor someone. With regard to decision of the RAC to appoint so and so as CPS to be implementing agency for upgrade project, the in place of so and so, we find the same is purity and admissive decision, and the change of implementing NC cannot be said to prejudice anybody. So that deviation was allowed because that will not affect with prejudice to anybody. If that is only meant for me only, then prejudice will appear to the other side. If there is a change of an admissive decision by way of forming a subcommittee, that will not prejudice. They can bring policy decision, they can bring. I think, my lord, that is what my case is about, my lord. 18/9/2023 formulation is 18/9/2023 is only, my lord, a guidelines which cannot be have any statutory in force. This is not a second. It is not a part of terms and conditions of the NIT. Third is, my lord, it is only by way of memorandum 18/9/2023, where 25th of January 2024, my lord, that a pre-bid meeting was held. And they decided as 18/9/2023 will be followed in consonant with standard bidding document 36.2 and 36.3. Number 5, when you go into 36.2, 36.3, then, my lord, 18/9/2023 will not come in. Because at the relevant time, when the financial bid is open, you have to look into that aspect of the matter. What was the market rate at that relevant time? Number 6, the government can take a decision. If that decision is arbitrary by forming a subcommittee, it should not affect a particular individual. It is related to all. So it will not prejudice. Now, government can review its own decision. If a policy decision is required for the public interest. And if your lordship looks into the conclusion, they have made all the market survey and everything, my lord. That is last argument will be CA para 506. That's my last argument. 506, I think your lordship.
We have seen it.
506.
We have seen it.
506, conclusion and recommendation. That's my argument before you. Yes. And all the judgment that has been quoted, I'll just put it, all the judgment which is quoted and accepted by a single judge, I express to defer that for all the judgment. Jairam Shetty was, my lord, shown. Jairam Shetty was completely different on the ground that it is an eligible bidder. Somebody has come into it who does not have the eligibility criteria. Supreme Court said that no, you cannot pick up one because there are other bidders who would like to participate. So that judgment, my lord, will not cover this case. Jagdish Mandal case, my lord, that's very interesting. If you see, my lord, last I will show it. They have quoted, the learned single judge has quoted a Jagdish Mandal judgment. See the Jagdish Mandal judgment. But I'm sorry, my lord, page 44, internal page is 11. Kindly see Jagdish Mandal, my lord, para 22. Para 22, kindly see of internal page 11. In case of Jagdish Mandal, in case of Jagdish Mandal, we relate judicial review of administrative actions intended to prevent arbitrariness, irrational, unreasonable bias and malafide. Its purpose to check whether choice of decision is made lawfully and not to check whether choice of decision is sound when the power of judicial review is invoked. In matter relating to tender or award of the contract, certain special features should be borne in mind. A contract is a commercial transaction. Now it's very important. Evaluating tenders and awarding of contracts are essential commercial function. Principal equity and natural justice stays at a decision. If the decision relating to award of contract is bona fide and is in the public interest, court will not, in exercise of power of judicial review, interfere. Now, even if a procedural aberration or error in the assessment of prejudice of a tender is made out. This is what I am saying, my lord. Suppose they have formed a subcommittee. So, my lord, forming a subcommittee, my lord, is not that you cannot say for a judicial review that is a wrong which has been made by forming a subcommittee. So, it says interfere even if a procedural aberration or error in assessment of prejudice tender is made out. Power of judicial review will not be permitted to be invoked to protect private interest in the cause of public interest. So public interest has to be looked into it. So this And my one last, this subcommittee report has not been put to challenge by them, neither by any of any of the district. It has not been put to challenge. It is final, and they have not challenged this subcommittee report as on date, and they knew it was open for the public on 12, and then which they filed this petition, they did not challenge the subcommittee. It was made open, and it is applicable to all the packages. They have no challenge is been made. Subcommittee report. Till today, it has not been put to challenge, to our knowledge. And the government will definitely have to say, or my learned friend can point out that subcommittee report has been put to challenge. There is a report. You have to challenge the report. You did not challenge the report. And my lord, it is not. It is to all the district, this subcommittee report. So this is my humble submission, my before your lord.
See,
I'm deeply obliged.
another
Yes.
is this about you only. Now about the petitioner, the same chief engineer,
About me, my lord.
about the petitioner,
Petitioner.
on the representation of the petitioner,
Yes.
he has directed the superintendent engineer to re-evaluate the tender and submit.
Yes.
Accordingly, it was submitted, recommending the name of the
That-
petitioner.
Yes. That
The same chief engineer is the chairman.
Correct,
the
right,
member of
right.
the
right,
subcommittee.
correct. The lordship is right.
How it's possible?
Yeah, correct. That's
You can be a chief engineer and maybe a member, a chairman of the committee. Don't you have that kind of thing?
he could not. My lord, why your lordship is absolutely right. That's what I want to say. That what you could have done.
Possible.
No, but then you have to leave that as a chairman. I will not be a part of.
You get the accommodation from the tender opening committee on
Yeah.
3rd and
And you send it
you issued an LOI to the appellant
to appellant
on 5th.
or not on
Now
5th,
that-
on 15th, on 15th. On 15th.
Mr. Perme, you have to justify. Yes, now you.
I'll begin with the last. I'll begin with the last.
I think because we took them to understand because of the facts and all other things. I think you just
There are two parts.
can you be a little brief?
So far as the facts are concerned, if the fact note there are missing links.
It's okay.
I have to fill the links.
We're not going
There
to.
are sequence of events which were missed and which are very vital for this case. That certainly will work. But we don't have to start with the last.
But we'll finish before 1 o'clock.
will be bit unfair for the simple reason.
Then
I will have to rebut
That-
whatever has controlled,
that will-
whatever has fallen.
that will be discrimination to your learned colleague, other colleague.
Such, you know, that there has to be a degree of.
Or you will be depriving your colleagues.
As a lawyer, I will have to iron out the pieces, number one. Number two, not
Then, no, sir, anyway, you try to finish it up before 1 o'clock. If it's not possible, we'll continue tomorrow because there's a Mosul matters, bail matters are there. So we'll continue tomorrow because you have to balance.
My interest that I finish with as short time as possible. I have got other matter.
It's a tender matter. It's a tender matter, sir.
But this far.
It's a tender matter. There's a, we are always of the view that now there's a,
I have not even started.
there's a gone, sir. We'll hear the senior lawyers in a tender matters for a week.
Because I have not started, my lord doesn't even know that how long I will take. I will take as short time.
But we will, if it is not to be, let us be very clear. If you cannot complete,
Half an hour,
we'll hear you again tomorrow.
half an hour.
Yes, please.
That's
We'll have to hear him also.
half an hour I'll complete my part.
Yes.
From about say 40 minutes to one. They were repeat the honorable court continues.
No one. Not one.
I will not repeat this in court.
No, sir.
I will not repeat this in court.
We're ready to hear you, but if it cannot be completed, we'll continue tomorrow. That's what I'm saying. Right? Yes.
All right. Let us begin, no?
Yes.
So we gonna start off. I'll begin last. That's the perfect.
Yes.
Not sufficiently long. That. But it fell from your lordship as to how come the chief engineer recommend the writ petitioner. It is precisely for this reason, my lord, that no mandamus was issued by the honorable court, giving a direction that X, Y, Z has to be done in my favor. The direction of the honorable court is the most eligible bidder has to be awarded the contract. Two persons are in the fray. My esteemed colleague's client and this side.
Yes.
Within the two, the decision has to be taken.
Yes.
Within the ambit and scope
Yes.
of the tender SBD. I'll put it this way. Now, my lord, to begin with, an impression has been sought to be created that the memorandum.
We're impressed by your first submission. We're impressed by your beginning.
Very well. My lord, I'm deeply obliged to my lord for the note of appreciation. Now, my lord, first come first. An impression has been sought to be created that the memorandum laying down the justification ranges dated 18/9/23 is not at all applicable to the facts and circumstances of the present case because it is meant for one particular year, which is beyond the scope of the NIT itself. Now, my lord, for a moment, just turn to the very memorandum laying down the justification of ranges at page 247. That makes it very clear whether it is applicable or not applicable. Page 247.
Yes.
Page 248. Para 5. Validity of justified bid price ranges. The justified bid price ranges provided herein as above shall be valid for the bids of the tenders floated and processed for award during the current financial year 23 to 24. The financial year will be 31/3/2023 to 1st of April 2024. This is the financial year. Tender floated and processed.
Is it so, sir?
Obviously, my lord. This is the only interpretation It is as simple as that.
No, I'm just asking on the lighter note.
Yes.
Financial year is 31st
March
March
2023
2023,
to 1st of April.
1st of April 2024.
Our
That's
first,
what I said, is it so?
yes, financial year. 1st April to 31st March to 31st March to 1st April, not anyway. Because don't know what happened prior to that. Okay, that's the first. Either way, my lord. So 31st March 2023 to 1st April 2024 is the financial year.
Yes.
Tenders floated and processed. Now, my lord, the tender floated on 17th of January 2024. Processed, floated and processed. Pre-bid meeting held on 25th January 2024.
Yes.
Now, price bid opened on 21st February 2024. So processed, floated and processed. Then 26 to 2024, comparative statement given. Process is complete. 12th March 24, letter of superintending engineer informing the respondent 9 about rejection of its bid. The first rejection is 12th March 24. The second rejection is 22nd March 24. The entire process, my lord, got completed within the currency and the lifespan of the memorandum laying down the justification of ranges that is dated 18/9/43. The argument doesn't hold water.
Within financial year. 23, 24.
Yes, the deed is done. So, my lord,
Last was which
now I can't.
financial bid of the
Your financial bid opening is just a minute. Lordship will be benefited if I hand this over.
The
That's all.
voting is
It
processed,
will make it very easy.
the voting is processed for award,
Floated and processed.
floated and processed for award.
Yes, the
So,
process
the conclusion has to be arrived.
floated and processed. Now the process has to be by tender evaluation committee. The tender evaluation committee processed it and took a call and found that this bid is rejected. That decision is taken. Even when the representation is submitted, even that is rejected within the financial year. So practically, my lord, the finale is over.
well,
What followed is, my lord, ultimately the decision of the government. Awarding the contract. So floated and processed is to be seen because the touchstone is, the anvil is justification of ranges 89/23. On that basis, they take a decision.
therefore it says plotted and processed
Process.
for award.
Yes.
So until the
Not the award may be thereafter.
Can you read? Plotted and processed for
For
award.
the award. So for the award can be after 1st of April. Award may be after 1st of April. But the analysis, the process is over. The bid is rejected.
Okay, next.
Now the second point. The very formation of subcommittee itself.
That copy.
That getting mixed up. Now the second point. The very formation of subcommittee. It is a legality of the subcommittee. Whether this now, once the law becomes to the conclusion that the memorandum laying down the justification of ranges written 89 is applicable, and the floating of the tender and process of the tender has to be done within that lifespan itself. Any decision taken thereafter, because we have to appreciate the fact that the subcommittee came into existence when the final decision of rejection of the bid of respondent 9 was complete. It is at that very particular stage subcommittee came into existence. Now, apparently, my lord, the finding of the learned single judge that there is no basis for the formation of a subcommittee. There is no power in the tender. There is no provision of law has not been driven. The formation of the subcommittee has been sought to be justified in public interest. There were complaints. Complaints are not in the record. We don't know. Complaints are not in the record. So, my lord, the formation of subcommittee per se is illegal. The counter argument is Subcommittee is illegal if it is formed on appellant's request. This was submitted. Well, if I am the person that I submitted a representation, if it is on my request, such a committee is formed, then it is illegal. Otherwise, it is not illegal. So, my lord, if I make a request, it is illegal if it is formed. Otherwise, it is not illegal, but we have to show the source of power. On what basis? That is point number one. The point number two would be whether formation of such a committee would tantamount to changing the rule of the game. Once the game has begun, here, my lord, the game not only began, game substantially got completed. Maybe, my lord, the entire match was over. Only the trophy was to be given. It was the final. Match got completed, goals were scored, trophy was to be given. Before the handing over of the trophy, committee gets formed. This is one part. There is a third part. Now, the judgment was placed before the honorable courts saying that a policy decision can certainly be taken if it prejudices no one. I would answer it this way. If a particular policy decision, number one, has no basis. Number two, when the policy decision is taken, a particular action is carried out, and if there is selective application of that very action, then certainly, my lord, the test of prejudice comes into play. I am making it very clear. There is a recommendation of subcommittee. The recommendation of subcommittee was not uniformly applied. The recommendation of subcommittee was exclusively applied in the case of my esteemed colleague. He was the sole beneficiary of the strange recommendation of subcommittee. In all other cases, they acted within the ambit and scope of the NIT. Read with 18.923 memorandum. I will show that.
Sir, before that, how do you apply this 18.9/2023 with clause 36?
Clause 36.
The concern is with.
Oh, yes. I'll answer. Now, my lord, may just turn to
Because they have clearly
I'm
said
showing it.
it will be taken.
I'm showing it. This will answer. The first rejection and second rejection answers the question. My lord, will just see clause 36, as lordship has noted, deals with abnormally low bid. Very well, lordship has seen the entire scope of the abnormally low bid. Now, my lord, lordship, for a moment will turn to the very justification, the reasons given in the page 313 में time के PC 313 With the help of this document, I will demonstrate. It is after the first rejection, the second paragraph. You are requested to furnish your justification for quoting abnormally low price bid in line with memorandum number such and such dated 18/9/23 of Government of Arunachal Pradesh in consonance with pre-bid meeting minutes issued by such and such dated 25th January 24 and clause 36.1 and clause 36.2 of the ITB. Further, you may also refer clause 36.3 while furnishing your justification. Now, my lord, the 18/9/23, as my lord has seen it already, it contains the entire list of all the items. The ranges, the price ranges are given in detail. Now, my lord, it is on that very particular basis that the clause 36 has to be seen and understood. If somebody quotes a price which is much lower than those very justification ranges, it would reason to, but the only conclusion would be it is abnormally low. And my lord, here they have said so in page 314. Second paragraph, the rejection itself. What do they say? Superintending engineer writes, you have quoted 54 crore 98 lakh 73,157.44 against 65 crore 46 lakh 10,958.44 put to tender, which is minus 16% below the estimated cost put to tender and minus 10.25% below the minimum justified rate. This is the answer of my lord's query. Memo number such and such dated 18/9/23 of Government of Arunachal Pradesh, which is abnormally low. So, my lord, this is how it is interpreted and looked into. You may also refer our pre-bid meeting minutes issued by number such and such dated 25th January 24, wherein it has been clearly mentioned at serial number 5 that the justified bid prices ranges approved by the high-level technical committee as circulated by above mentioned memorandum will be taken into consideration at the time price bid evaluation of bidders. So, my lord, this is how 18/9/23 justification of ranges memorandum along with clause 36 they are looked into and my lord, decision is taken as to whether a particular bid is abnormally low or not. This is, my lord, this is what it is throughout. Now, my lord, another thing I would show to my lord about the selective application because that was me with the test of prejudice. How it is selectively applied. The very recommendation of subcommittee, and herein comes the principle of Jagdish Mandal. Why Jagdish Mandal? Because when it is seen from the conduct, from the action, that particular action is to give benefit to a particular individual, then the ulterior motive comes in. And this is what Jagdish Mandal is all about.
Fact
Why not make IDC?
But in fact, remains that all the packages, 6 packages, were re-evaluated or re-examined by the subcommittee, including the Pasikat package.
But award was given in terms of tender evaluation committees.
Without accepting the
Yes.
report of the committee.
Lordship may have a look now. I've given that. And I've given the page numbers from our report.
Oh, yes.
Lordship will just the first page itself. Analysis of Rupa package, page 504 of the report. Now, government, we have given all the figures. Government estimate is as per the NIT 31.11 crores. Estimated cost. 2. Range of justified rate notified by the government of Arunachal Pradesh rupees 30.85 crores to 31.18 crores. Because this is as per 18/9/23 memorandum of justification of ranges. Range of justified rate. Then market survey analysis rate rupees 22.18 crore as per subcommittee report. Lowest rate quoted L1 Mr. Jayant account amount 55.76 crores, approximately 16.13% above market survey rates. Rejected by DEC for being abnormally low. DEC rejected him, but below the market survey analysis of subcommittee found him eligible. Highest rate quoted by Mrs. TNT project L3 rupees 31.92 crores approximately. However, LOI dated 21/4/25 was issued in its favor. Page number 573, 574. So this is it. Because the rate quoted by Mrs. TNT project satisfied the test of the tender evaluation. Satisfied the test laid down by 18/9/23 memorandum. Whereas the subcommittee in its recommendation said all those who are abnormally low and were rejected, in fact, the rates given by them were in terms of the market rates, which are going on. So this is it. Then same Milord for Nahar Lagoon package. Not you will see the figures. In the case of Nahar Lagoon, Milord, the letter of award has been made. It has been awarded contract already. They never followed it. Same Itanagar package. Now I'll come to the Pasighat. Our case, the only deviation is Milord in respect of Pasighat. Our case. Not you will see the next page. D. Pasighat. Government estimate 65.46 crores approximate. Range of justified rate notified by the government of Andhra Pradesh, rupees 61.27 crore to 67.56 crore. Market survey analysis rate 47.02 crore. As per subcommittee report. Basis DG construction, that is without V, the petitioner for the honorable court. 64.33 crores, approximately. Lowest rate, L1, Mrs. Techno Power Enterprises, amount 61.42 crores, approximately. Declared L1 by Ds. Mr. Wind Power and Private Limited, amount 54.99 crores, rejected by the DEC for being abnormally low. However, LOI dated 50.25, 353, 354 was issued in its favor on the basis of the subcommittee report. So, my lord, the subcommittee report was followed only in respect of Pasighat package and not in respect of any other package. My lord, I have been instructed to inform my lord. There were two other packages, Deoban and Lamsai. Same thing has happened here also. So, my lord, we are the only special people. We did out very, very special treatment by the subcommittee. It is we who have been wrong.
That's why you all are for us.
That is why we don't have, that's why we came before the honorable court by way of it. All these things are clear, we have given the difference of each numbers. Now, my lord, Dr. has seen all that without the entire sequence of events. I would not cover my lord with all that. Maybe we not skip it. I need without their reply. How Jagdish Mandal comes in. How Jagdish Mandal comes in, I have explained. In what way it comes in. The relevant para of Jagdish Mandal, I am relying on its 2007-14 SEC 517 paragraph 22. Para 22 of Jagdish Mandal. It is precisely on that purpose. And this is what my Lord Justice Mehdi also referred. My Lord Justice Mehdi said, evaluation after evaluation till you reach the desired result. Desired result was reached in our case. Because selectively they implemented the subcommittees.
It equally applies to you. Your name has been recommended
You know, as
or not on the first.
we are not seeking a writ of mandamus saying award it to us. We simply say, look, yeah, he could not have been awarded. Techno power is not in the fray. Now, between the two, who's most eligible? Find out in terms of the
No,
parameter.
that's why we said we're impressed.
That's it. So
When you began, we were impressed. Now,
Which paragraph you're referring to?
Jagdish Pandit paragraph 20. Now, my lord, changing rule of the game midway. The principle laid down in Tej Prakash. Though, my lord, it's a principle of administrative law, it applies over here also. Supreme Court invoked this principle in service matter in the case of recruitment, etc. But not it being a principle of administrative law, let a single judge also look into this aspect. So, changing rule of the game. Tej Prakash, paragraph 65.2, page 37. 2025, 2 SCC, page 1. Tej Prakash. Paragraph 65.2, page 37. Citation 2025, volume 2, SCC, page 1. Then the third judgment without why, and I will explain this why I am relying on this. Ramana Dhanam Shetty versus International Airport Authority. That is 1979, 3 SCC, page 489. I repeat, 1979, 3 SCC, page 489. Relevant page 503, paragraph 10. I'm sorry. So we got International Airport Authority, 1979, 3 SCC, 489, page 503, paragraph 10. I explain why. Reason being, my lord, the famous observation, my lord, of Justice Frank Carter in Vittorali versus Cito, namely, he that takes the procedural saw shall perish with the saw. Quote unquote. Here we are on the point. 18923 memorandum, you accept. In pre-bid meeting, you categorically say 18/9/23 memorandum of justification of ranges will be followed by us to determine the eligible bidder. That takes the procedural sort. So this is the procedural sort you had taken in your hand. If you do not follow the sword will follow. That is Ramanatya Aramchi. And you say something, follow it. Because an authority shall be rigorously judged by the standard it set for itself. It professes to be just is the word used. So, they set for themselves a standard. They chose.
That what's in little leg?
My Lord, that's-
5+1.
My Lord, I was quoting this motion. That is why, my Lord, I accordingly, my Lord, engineered my entire argument, looking at the watch behind me.
But that is
Very well.
yes.
Only
All-
one
all,
line, only last line. It was argued that the recommendation of subcommittee, the report of subcommittee is not under challenge. I have got two answers. Number one, we have not challenged the report of the subcommittee, we have challenged the action taken on the basis of the report of the subcommittee. We are concerned with the action because subcommittee's recommendation was followed only in passing out package. We have challenged the action, namely the LOI issued in his favor. So therefore, my Lord, we are not separately required to challenge the entire subcommittee's report. Why should we challenge it? And number two, it is expressing legal. Ab initio void. No challenge, further challenge is required. It is not in conformity, my Lord, with the standard by which they profess themselves to be judged.
No, basically,
Article 14 comes in.
Otherwise, are you agreed by the constitution of?
We are not agreed. How does it matter to us? We simply say, look, follow the procedure. Correct. We are decision-making process which was correctly followed.
Yes, equally, some other, I mean, technical evaluation committee or something. Some committee has also again re-evaluate and re-examine your bid and recommended it.
That is it. That is it.
Same thing, you are all are stand in same footing. So difference is one is by the subcommittee, other is by the technical evaluation committee.
Not we put it this way, we are not.
And appears to be, it's the subcommittee is headed by, I mean, chief engineer. The technical evaluation committee is headed by the superintendent.
My Lord, I'll put it this way.
There's a conflict between
My
them.
Lord, there is no parity. There is no parity as such.
There's no working in coordination.
My Lord,
Rather, they're.
He has gone one step, sorry, he has gone one step ahead. Because when this matter was taken up by division bench, there was a status quo to be granted by this court on 7th, 3/7/2025. Now we received an office order whereby he has given a work order to
it
them
was
by the
recalled
superintendent.
also. It was recalled also. It was
Recalled.
recalled also.
But
so I
you-
have so many
But
concerns.
whatever,
Sir,
whatever he is so interested.
Sir, sir, time is very short for me. In any case, my Lord has come down very, very heavily.
Yes.
You are reading up even that time. Very well. So, that's there. So, my Lord, what is under challenge is the action taken on the basis of the recommendation of committee, namely 15/1/2025, letter of superintending engineer calling upon the appellant to submit unconditional and irrevocable bank guarantees. And my Lord, issuing LOI in his favor. That is under challenge. That is on the basis of the report of the committee. I'll just clarify only one aspect. Why we are not at par? We are not at par for the very simple reason. He is the creature of the committee. Had committee's recommendation not been there, he would not have been in the play at all. So far as we are concerned, we are part of the process which was undertaken within the everything scope of the pre-bid meeting. learned friend is pushed aside. Only two players are in the fray. Techno power withdrawn, not in the fray at all. Only 1% is there. If we are very, very close, and my lord, secondly, it is not the supra TEC that has looked into our case. It is the TEC itself. Practically, my lord, it is a review of the case on the basis of inputs that we have provided. They have examined it within the ambit and the scope of the memorandum of 18/9/23 and the pre-bid meeting. So within that very scope, my lord, if we are found to be very, very close, my submission would be there is nothing wrong. But in any case, my lord, the mandamus of the honorable court is not ipso facto in our favor.
We
Court
can-
only said the most eligible bidder.
We cannot blame either the appellant or the respondent or the writ petitioner. This is all the creation of the government.
Lastly,
We cannot-
my lord, I will place the division bench judgment in Tractors and Forms case. It is only when the view of learned single judge is highly improbable, totally arbitrary, then only my lord will interfere with it. In the event, my lord finds that the view taken by learned single judge could have been taken in the facts and circumstances of the case, that would not be a ground to set aside the judgment of single judge in a writ appeal. The citation is 2004, 1 GLT, page 117. The relevant paragraph is paragraph 26,
Page,
page 117, 2004, 1 GLT, 117, relevant paragraph, paragraph 26. The principle is, if merely because another view is possible, will not be a sufficient ground to set aside the judgment of single judge. Unless and until it is highly, the findings are arbitrary, improbable, ex facie illegal, or perverse. Otherwise, not. So that's my submission. my lord.
how long you'll take? What 5 minutes?
It's to answer.
You are the real creator.
And my lord, in case, if my lord,
Will not be able to convince in 5 minutes. Rather, we'd like to hear you
my
actually
lord, in passing,
30 minutes.
if my lord, any clarification is necessary for me, then my lord, I may be given that opportunity. Or if my lord feels that some kind of write-up will be necessary in this case, it is required to be given.
No, we first would like to give
Right,
them an opportunity.
right.
So it's asking when tomorrow or day after tomorrow? Day after.
I'll be in online, my lord. Online.
We have heard.
Yes, no, my lord, some reply has to be given. Only one request is being with my learned friend, I think.
Online is very difficult. No. It's
It's-
your own risk and cost. We cannot deny you, but your own
Only one request is,
risk and cost.
my lord, wait, one request is being made. If it is not income,
Tomorrow, I will think that. Tomorrow.
I will have, let him stay back, my lord. I'll be in online, I will take that risk if necessary, man, in online. And one item number 4, my lord.
No, there are bail matters, motion matters, so we'll have to, yes, we'll have to balance.
Wha-
Yes.
No, item number 4, we appear in one of the case.
Okay.
I am the respondent in that matter, my lord.
I'm the appellant.
Appellant. And there is some,
Yes,
there is some urgency in this matter.
Yes, yes.
So if it is not inconvenient to your lordship, can be taken up on Monday, my lord, subject to convenience of this court.
Monday. I think Tuesday. Tuesday.
Wednesday. Convene for.
No, one matter.
No, I don't know, my brother judges. If I sit here, I make it a point that, I mean, Many that it's only the Tuesday and Thursday, division bench. Unless there's a fix or, I mean, urgent matters. Matter, because we find that, neither the division bench nor the single bench is effectively the
There is a stay which is operating in his favor and is working. That's the whole problem. So I just suggested if possible, I'll finish my part on Monday, let it be on Monday and he can finish it on Tuesday, there is no problem. Yes,
It
appeal.
will be done, madam, but Monday, and Tuesday, I got to get better,
No,
madam.
let him do on Wednesday, my part I'll finish.
Wednesday, I'll come and clean.
Well, I'll finish on Monday, I will try to finish.
Whether this bench is
My-
available or no, it's not, it's
So Monday will,
very, very different bench.
yes, Monday.
Monday.
So Monday,
Monday, madam, I've got a matter to be very frank in Delhi, my lord, I have. No, you decide.
no, Monday, let it be remain the list, my lord. Monday and
Monday,
Wednesday
when
he
I
can.
know that I've got a matter in Delhi, I have to appear before. This list will be accessed today. Now, 1 o'clock.
So let it be on next week.
27th, my lord, no, you decided it. The first, I think, Wednesday. Just wait. I think to urge so and so. Let me see the
Wednesday.
assisted by so and so. And item 2, huh? For the applicant, it's the PKT that senior counsel assisted by Miscellaneous counsel to the respondent number. One, oblique writ petition. And Mr. No, part in, third in part, and let this matter be listed tomorrow. Yes, tomorrow.
Why are you talking that?
Then first, let, after tomorrow.
Everybody's doing it. Yes, I have my problem. That's why I'm saying that. Okay.
You said five minutes. Tomorrow. Third in part, list is better. Again, on so and so. Give that. Oh, okay.
Will be online.
More, we have agreed on 27.
27.
In item 4, is agreed to the then of the senior council agreed with parties. Which board appellate? I'm for them. This, thus, is this better on 27? 27/08/20.
Can it be on a first item itself? And if it is possible, request is being made. Request is made by the,
2025.
yeah, if it is possible, request is being made. Your will, not a one line, it will make difference. Yes, fine.
Make the things upside down. I don't only notice, may only my learn.
Final disposal.
Final disposal. It's okay.
Final disposal,
Okay, we've agreed. This is listed for a list for
admission here.
for admission hearing.
Oh, fine.
Offline.
I am deeply obliged.
Final. Both the sides have agreed. We are not saying final hearing, it is for admission. No, because this is listed for orders of.
Yes, I am deeply obliged.
Well, Lordship may say that both the parties have agreed that taken up a
It's
final.
okay.
Offline.
Small matter that big matter, big thing only, in matter.
Yes, we'll pass the order, allowed. Any objection? No objection. This allow, will dictate. Okay. It's implement.
Both suspension and then. Both suspension also filed the application for suspension, that then they are also in different matter.
Separate order, same petition.
Connected matter. Appeal, main appeal and sub.
And appeal and the suspension by two IAs.
Yes, two IS. One is.
Two IAs and responding.
And madam, madam, allow while the amended post item.
Yes, obvious.
That,
Oh.
I think,
Obvious.
Madam, I beg to mention item number 12, Madam. Madam, I could not receive the instruction from department, Madam. I may be granted, Madam, 3 weeks' time. I've taken consent from the petitioner, Madam.
On the prayer of Mr. T. Thakur, that still in council. Yes, department. That will be listed.
3 weeks.
So it's whenever. Right, that's a different opposition.
Yes, madam. Deeply aware. Yeah, please, your lordship. Lordship, I beg to mention one IA, lordship, to be listed today, lordship. IA, lordship, just for implement, lordship.
For
Lordship, I beg to mention item number 8 on the behalf of DK Theory, is a petitioner, and I have already informed the other side also. Taken the consent. The matter may be kindly fixed for after 2 weeks.
on the prayer of Mr. Let's ensure then the council appearing on the that this method be disrupted.
My lord, item number 9, the matter may be adjourned for the 3 weeks as the leading counsel is unable to appear due to the illness.
9,
Yeah, item number 9.
therefore,
T. Garam.
on the ground that Mr. T. Garam council has shown some difficulty today from a MS and council appearing on his behalf. Praise for listing of the matter after 3 weeks. Praise the Lord, list after 3 weeks. Please.
Obliged.
Mayor Lords, I beg to mention item number 7.
Hmm.
Here we have to file additional affidavits, so we may be given some time.
Further 3 weeks time
Yes, Your Lordship.
is granted to MST Somo Learning Council today. Yes, Somo.
Yes, Your Lordship.
Yes, Somo Learning Council today. But affidavit in reply.
Much-
My lord, I beg to mention item number 18 and 19. My lord, I am respondent number 3. I need at least 1 week time for affidavit, filing affidavit and reply.
18 and 19.
Yes, my lord.
Yes. On the prayer of Mr. Udeka. Affidavit,
Yes, my lord.
Udeka, Learning Council for respondent number,
3, my lord.
respondent number. This the matter, this matter after 3 weeks. So as to enable him to file affidavit
Yes, my lord.
in opposition, yes.
My lord, interim is there, my lord.
Interim order passed and missing.
Alright.
Item number 1.
My lord, I am appearing for the petitioner, my lord. My lord, in this, my lord, there was one case has been lost, my lord, in which if my lord will come to directly annex a P3, my lord, of my petition, my lord. My lord, there one notice was being served upon me, my lord. I have the petitioner has complied with that notice, my lord. My lord, it is in page number 47, my lord, of the petition, my lord.
What?
My
Page,
lord, there, page 47, my lord. 47,
Yes.
and except P3, my lord. My lord,
Hmm.
this was the notice which has been served, my lord. I have complied with that notice, my lord. The notice was earlier served.
on
It
being
is on the
examined,
page,
that I am running from.
page 46, my lord. Page 46, my lord. The notice which has been served, and this is the means we have joined, my lord. And in this, my lord, I am not the FIR name accused, my lord. The rest of the FIR name accused has been granted bail. Some of the accused has been granted bail by this honorable court, my lord. My lord, there is one, I have gone, pardon, my lord.
This is what? This is page 47 is what?
This page 47 is the statement, my lord, which I have made before, my lord. It is running till page number 50, my lord. 50. 50 is a type copy of one ineligible paper, my lord. This is the petitioner who have joined the investigation before the police officer, my lord, who had visited from Itanagar itself, my lord.
So why you have already, you have given this statement, how you are apprehending?
My lord, after that, my lord, few notices we have got, my lord, from GST, my lord. That's why we are apprehending, my lord.
Where is the notice?
My lord, notice is not over here, my lord. We are still, my lord, only they wanted some statements. And after that, my lord, few people were arrested, my lord.
You appear and give a statement.
Lord, my
What is the
interim protection,
What What is the allegation?
My lord, allegation against me is nothing, my lord. I am nowhere connected with this FIR, my lord. There was some 99 crore rupees fraud of the GST something, my lord. And then this case was started, my lord. The person who are the main accused over here, they are the accountant of my firm. I have a firm. They manage they do my books of accounts, my lord.
You are
Over
the
there,
proprietor.
yes, my lord. I am a proprietor of some other firm, my lord. Where this Asuto
We'll call for the case diary.
oblige, my lord.
Yes, in connected matters, this court has rejected the bail of
My lord,
one Bipin Kumar Jha.
yes, my lord. But
We'll see.
in Asutosh Kumar Jha,
Accused
my
are
lord.
your employee.
Accused are not my employee, my lord. I am one of the petitioner, my lord, who is not named in the FIR. Those accused are my lord, accountant. They were running a chartered accounting, some kind of firm, my lord, where they used to do filing of GST return, tax return. That is how it's going on, my lord.
Chartered
They are
accountant.
one.
They're chartered accountant.
Yes, my lord. They're
You engage them.
yes, my lord.
Have you
I have
engaged them?
engaged. Yes, my lord. I have engaged them. One of that person. Pardon, my lord.
We'll call for the case diary.
Oblige, my lord. Oblige, my lord. Are in one criminal petition 188, my lord, where Asutosh Kumar Jha is one of the petitioner over there. He was granted interim protection, my lord, on the base of one another petition, petition number 6 of 2025, my lord.
Where it is.
My lord, today I have, my lord, day before yesterday I have got that. By that time of
No,
filing of this petition, it was,
in same matter,
yes, my lord.
this court has rejected the bail.
Yes, my lord. In one of the petition, my lord. My lord is correctly, my lord.
182 of 2024.
Yes, my lord. But there is one another, my lord. 188, my lord. 88.
No. You are seeking bail in which case?
My lord, 182.
182.
FIR. Yes, my lord. FIR number 182.
We'll see.
And I am
Heard Mr.
Mohammed
Afzal
Afzal
Ansari,
Ansari. Yes, my lord.
learned counsel for the applicant,
Yes, my lord.
Mr.
Faiz Ahmad.
This is an application under section 482 of BNSS, 2023. Praying for grant of privilege of pre-arrest bail to the accused applicant, namely Faiz Ahmad, in connection with Itanagar PS case number 182 of 2024. Under section 120, capital B, 420, 468, 467, 468, 471, 470, 470 of IPC 1860. Call for the case there.
Scan copy, Lordship. Scan copy of President.
Call for the scan copy of the case there. MS next para L Hagen London Register. It appears for the state performance. State appears for the state official PP, huh? Just the matter after when?
After a week, Lordship. After a week, Lordship.
After a week.
Oblige, my lord.
Will you give them?
My lord, by that time, I can't get the interim protection or something like that, my lord. No
We'll see it on
coercive-
next day.
Oblige,
We'll
my
see
lord.
on next day.
Oblige, my lord.
This don't
Oblige.
give that date. This don't
Oblige.
say what?
626.
Item number 2.
Will issue notice. When is the promotion order is of which year?
Of
Which month?
March, my love.
March.
Yes, madam.
This is August. We'll see. We'll issue notice.
Madam,
What is
only
what
observation.
is technician? What is called? What is the degree? Diploma?
Technician engineer, madam.
What is technician engineer? From where you have obtained this?
Lordship,
And it's
the
not
record.
recognized by AICT.
Lordship, it's for the degree, Lordship. It's for the certificate. Yes, it is recognized by the AIC.
How?
Lordship, itself, it is there in the certificate itself.
Huh? They are saying that we have not heard about this. Is a diploma or degree?
Lordship, it is equivalent to diploma degree, Lordship.
It is recognized by AICT.
Lordship, correct. It's recognized.
My lord,
No, I'm just asking, is it recognized?
Lordship, as per my instructions, Lordship, it is recognized.
my lord,
Are there any documents to show that?
Lordship, till date too, I don't have that.
We have never
I have
heard
to,
of it.
I have to get the instruction.
Have you heard of it?
Lordship,
Not as a council, as a common man or as a, not a council, but a respondent.
Lordship, first time I am dealing such case, Lordship, so why, Lordship?
No, we have never come across a technician engineer. What is this? There may be, but appears to be not recognized. Very clear. Just because they have come little late, so we're not passing any issue on. Already promoted,
yes, my lord.
it has been affected already.
Lordship,
My lord,
they are already serving, Lordship, posted.
my lord, only my lord, the observation, my lord, in case in that case, my lord,
What is-
subject to outcome, my lord.
Obviously. Privacy appears to be, it's not a recognized diploma.
I'll get proper instruction. Lordship.
Otherwise, what's your initial appointment?
I was a surveyor, Lordship. I was
Surveyor.
appointed as a surveyor.
Surveyor,
And
what
then
is your
promoted
degree or
to
diploma?
JE, Lordship, then after JE.
No, what is your basic,
ITI,
ITI, Lordship.
industrial training.
Okay. Thereafter, no diploma, other than this
Other than this,
technician engineer.
Lordship, yes.
What were the rules permits, the promotion?
Lordship, as per RR Lordship, we are permitted. Since I was serving as JE, Lordship.
Let us see the RR.
My lord, RR, my lord, at page 52, my lord.
Hmm.
That is latest amendment, my lord, 2008, my lord.
Hmm.
That column 12 that has been amended and substituted
Hmm.
by promotion from amongst the junior engineer of department who have rendered 8 years of regular service in the grade and pass in account examination as junior engineer.
Yes.
Now, now thereafter, my lord, this part, my lord, after this, my lord, the government of Arunachal Pradesh, my lord, they have notified, my lord, they have fixed the minimum education qualification for graduation for all group A and B. But there is specifically mentioned that for engineer department, minimum education qualification diploma for group A and B. Madam. Now it's assistant engineers of group A. Madam. Now here, madam, if it is the promotion is based on the diploma, madam, on the certificate, madam, then it is not tenable, madam. That part, madam, because the certificate, the diploma, is not approved by AICT. So
Otherwise,
more
it is-
about the distance education,
Otherwise, it is approved. If it is recognized,
madam.
then no issue.
Madam, in that in case that it is there could have been no issue, madam.
Let us see.
Madam,
You don't know, you are not able to show that it is not been recognized.
madam,
Can you show that it's not been recognized?
madam, will in the meantime we'll file, madam. The AICT, they have published the list of various technical institution, madam.
But you don't have that.
Madam, that is with there, but we could not annex the, that list, approved list here, madam. But on the affidavit and pleading, we have taken that this is not approved by AICT.
But
That
that's why we want to see whether this is being recognized or not.
Madam,
If it is.
we'll bring it on record, madam, in the meantime.
In any case, anyway, who are you?
Madam, we are serving as a diploma. We are the regular engineering obtained through regular mode, madam. Our educational qualification, regular. Madam.
Direct recruit.
Yes, madam. That regular and the educational qualification we obtained through regular mode of the course, madam.
What is that?
Uh,
B.
PE as well as diploma. Some of them are diploma and some of them are PE, madam.
When you were recruited as a junior engineer,
My lord, that part, my lord,
and when these respondents were recruited, I mean promoted to the post of junior engineer,
that part, my lord. Engineer, this private responded, madam, they were appointed joined as a J in 1997.
1997.
Yes, madam.
Where is the promotion order?
Promotion order is at madam, page 71.
71.
Year number 5 and 6.
Art Mr. T. Thakur, then counsel for the petitioners. Challenge made in this petition is to the order dated 28, 28,
Madam, yes.
28/03/2025. Commissioner. PH. Except one, six. Respondent number 5 and 6.
Yes, ma'am.
5 and 6 have been promoted to the post of assistant engineer on the basis of the recommendation of the,
Madam, sorry, 4 and 5, madam, the respondent.
4 and 5, the post of assistant engineer on the basis of the recommendation of DPC. Mr. It is the contention of the petition that the petition respondent number 4 and 5 are not having valid diploma degree certificate as the certificate of the as their certificates being technician engineer obtained from what?
Obtained from, madam,
The obtained from the distance mode of education from the institution of civil engineers in India. Bracket clause is not a recognized degree or diploma certificate by All India. What is this?
All India Council of
Council for Technical Education. Issue notice returnable by 4 weeks. As Mr. Wish, Arvasir Lanet, State Council, and Mr. Is in the Council for Respondent, and then Council for David Respondent, level 4 and 5, and face appearance on behalf of others. No problem. No action. That's all.
Madam, the promotion made to the petition web subject to the
It has to object that promotion, until promotion order that is shall be subject to the some of this.
and caveat may be discharged.
Yeah, give it third Mr. Give it this thing discharge. No?
Okay.
Item number 3,
Who is appearing for this? Are you appearing? Obtain instruction tomorrow. Appointment of secretary.
No.
What is this?
Item number 3.
Okay. What is this?
This is ALC service. Auxiliary Level Corps service.
Oh, termination.
Karadari district.
Oh, release.
Yes, yes.
Okay, so
Page number 14.
Mr. Torum,
Yes.
I have gone through your petition, but then I could not make out. I couldn't understand what you want to say. There is a judgment of this court
Yes.
to consider your case,
Yes.
right? Then
Accordingly, I have been reinstated in my service.
what is the order of the judge? This court?
Page number 16.
Consider
page number
if
15,
it's
order.
disposal with direction to file you have filed a representation.
Yes.
This will so and so to is considered disclosed by work speaking order. It's also made clear which commission take into account not only so and so, except the district, but also by the. Where is the order?
Next page, page number 19 is the
It's not
order.
in speaking order. There's no speaking order.
It's on the
right.
basis, yes, on the basis of this order.
What does it mean? The following so and so are hereby registered agency from the date they were sent to superannuation after attaining 45 years of age. What does it mean?
My lord, let me clarify here. One, superannuation order was issued.
Hmm.
Superannuation order issued
You have
by
challenged.
by releasing my service
Yes.
when my age was attained 45 years.
Yes.
And it was challenged before this honorable court. This honorable court was pleased to observe that every government, every public servant has to be retired from the service when they attain 60 years.
Why you are realized? Why you have been released on superannuation after attaining age of 45 years?
Yes, it was challenged. And that was one separate rule from the government of India saying that ALC service has to release from the service when attain 45 years of age.
Yes.
On that particular order, my age of service, my age was counted as 45 years. And after challenging that order before the honorable court, the honorable court opined that the service of the petitioner has to be retired from the 60 years of age when attain the 60 years. Accordingly, after passing of the order from the honorable court, the learned Deputy Commissioner, the responding authority, page number 19, Annex 3, I have been reinstated in the service.
Hmm.
And here, sir, after reinstatement of the service, again, the responding authority passed an order that is passed July 2025, that's page number 20. Again, release my service from my service. That's I think the ground that I have attained 60 years of age.
So
So here my question, when the same office, while passing the order dated 19 April
recently,
2022,
I don't understand.
yes,
Earlier it was 45 years you have been released,
yes,
but then on your submission, court has directed you to file a detailed representation,
yes.
and the authority has to pass an speaking order. No speaking order was passed. Simply you have been reinstated, right? Along with two others. Today you are only alone.
Yes, that we
Then
earlier,
after reinstatement by an order dated 23rd April 25, by this impugn order you have been released on being found that as per the service book you have already attained the age of 60 years. What's wrong here?
my lord,
Just because earlier you have been reinstated, there was no mandamus, there's no effective order that you should not be released by now. Simply it was a kind of
my lord, my contention.
so as per the service book, if it is 60 years, what can we do?
My lord, once
Just because mention is made that with 45 years you have been wrongly on the basis of the central government notification, you have been wrongly released. Now, if you have attained 60 years,
yes,
that time maybe there may be mistake. They just have looked on the this thing circular of central government. which allows the ALC to go on retirement or released from service on attaining age of 45 years. Might be a mistake. Now, by this interim order, release order, you have attained as per the 60 years as per the service record. What's there? What's wrong?
My lord, in this regarding ALC service, there is no such a specific appointment order also. And frankly, there is no such appointment order in proper way. Only
Then,
we
then
counting.
your LC serving as a LC is there's no legal backing. If you think that there's no appointment order, it's simply you serve also.
If we counting the payment voucher, so my age was determined while passing the superannuation order. I was 45 years. After pendency,
Service book. It says service book, as per service book.
so my lord, notice may be issued and call for.
You don't know.
reports.
You don't know what is your age.
While
Very
passing,
difficult.
while passing the superannuation order also, proper notice was not issued.
Hmm?
Proper notice of superannuation was also not served.
You don't know your age. You may be more than 60 years, 70 years.
So that's why, my lord, I'm praying for issue notice and call for the report whether my.
Issuance of notice also. Anyway, not Mr. I'm just simply issuing notice. It doesn't deserve notice also. Once, as per the service book, if you have attained already 60 years, what's there? You are not questioning the service book. I mean, they is recorded in the service book. It is the basic.
Simply notice maybe issued so well.
In fact, I have understood, but what I wanted to, indicate you was that you don't have a case. That's why I said I don't understand you. What sort of kind of petition? But it doesn't look nice if I directly on your face pressing. Not Mr. Peter, I will counsel for the petition. Challenge, agreed by the released order dated 1st of July, 01/07/2025, issued by the Deputy Commissioner of Canada District, releasing the petitioner from ALC, within bracket, use the auxiliary labor corps, within bracket ALC, under, from the establishment of the Deputy Commission Canada on attaining the age of superannuation of 60 years as on 21/01/2022, as per the service book. This present petition is issue notice returnable by 4 weeks. Since MS are persons when what about two others? Two others still here
Remain in the service.
because they have not attained 60 years. Anyway,
I realize.
yes.
Item number 4.
May I, my lord? In this writ petition, there are 9 petitioners, including me, and I have been authorized to represent among all. I am challenging the unlawful, arbitrary, and malafide action of the respondent authorities in disbursing compensation amount in respect of the ancestral land known as Pave Modi under Giva village, under Giva circle, it's Giva village, Upper Swansea district. This land is acquired for, state acquired for construction of frontier highway from Huri to Talia.
Dispute between whom?
Actually, this is Mingya family ancestral land. and dispute is
Certainly,
among the
yeah.
brothers. And matter is subject matter under matter is pending before the learned civil judge.
Your friend is also party here. With Mr. Arti Sogu, Advocate Arti Sogu.
This actually he was appointed. He was our leading counsel for the title suit, and when
So
they
why
make
you have made him
fraudulent
a party?
agreement and they withdraw the title suit without consent of the other party, remaining party.
Are you
In the
challenging the duel?
withdrawal that also. And this title suit has been again this case has been filed in the civil court senior division Daporizo for restoration, and matter is fixed for this 22 of this month.
I don't encourage. Why you should make him a party?
My lord,
Why he should be a party? He has acted as a lawyer.
no,
I mean, counsel.
we have informed him, intimate him to do not withdraw the case because we are
Who has informed?
aggrieved party. The party has been split.
What is his right? What is their right to form the lawyer of the other side? Was the lawyer of the other side?
Lawyer is from my side only, and we are the 23 entitled, so there are 23.
Better you advise your client, don't unnecessarily drag your friend. Not at least in the writ petition. If yes, then if you allege some misconduct, there will be a way out. You can make complaint to the
My
bar
lord.
council.
Uh,
According to you, if there is any misconduct as a lawyer. But it's a kind of, you should not encourage this.
my lord,
Basically, you are
my lord, kind
alleging misconduct by this learned advocate.
my lord, kindly come to the page 46.
What do you want by this petition? Who is arguing? Are you arguing? Who is arguing? Either of the two.
My lord, my main contention is that humble submission is
Have
When-
some, sir, have some decorum, minimum decorum.
when the my lord,
It should not be encouraged even in the district judiciary, district court. To the municipal court. Equally, it has to be maintained. Will maintain. Litigants will not be knowing all these nitty-gritties. The basic thing as a lawyer and you have to maintain the basic decorum, minimum.
my lord,
That's the reason you have made him a party. What's the procedure? If you are alleging, see, tomorrow, I'm not saying that, God willing, God forbid, nothing would happen to you all as a lawyer, but it may happen to you. There may be allegation against you.
yes, ma'am.
Why don't you think before this? Advise your client.
Because they counsel act arbitrarily without
What's
listening.
the question of arbitrarily? Either he has acted legally or as per the instruction,
I'll-
or he has acted, he has misconduct, he has,
We clearly inform him to
his
do not
action
withdraw.
might have been, amounts to misconduct for which you have a appropriate remedy.
So we thought he must be necessary party.
Don't succumb to the instruction of your client, litigants. Anyway, we were issuing notice, think over it.
My lord,
It may happen to you also tomorrow. Are you getting my point?
yes,
Allegation is allegation. You have to maintain. Not Mr. We're issuing notice. Think about it. Am I clear?
Yes. My lord got it.
See, allegation there can be many allegations tomorrow against you also by some litigants. If really, we were not saying that if the lawyer has acted in a manner which amounts to misconduct, there's a remedy. Anyone can make a complaint before the bar council. Right? Not just because there's any allegation that he has withdrawn the petition. So you are claiming, you are filing a writ petition, making them a party. How many petitioners?
9, my lord.
The petitioners, 9 in numbers,
My lord,
claims to be the owners of the land. What land?
ancestral land,
Ancestral land.
namely Pawem Modi.
What is the spelling?
PA,
PA.
PAB, vegetable, small b, Modi, MODI.
No, claims to be the landowners. Of PAB, Modi under Giver Circle, which has been acquired for construction of the part of the frontier highway from Buri to Talia in the district of Upper Subcommittee, Upper Subcommittee of Arunachal Pradesh. District. Have prayed for a direction to the respondent authorities to what? Properly assess. What is your prayer?
My specific prayer is, my lord, in interim, to call back the check amount, which was issued to respondent number 5.
Said to prayed for a direction to disperse the compensation amount after proper determination of rights of members of the Mangnia clan having interest in the interest on the land, interest in the land. It is the contents of the petitioners that before the title of the compensation in favor of the before the title of the land is no prior to the decision of the title over the land between the petitioner and the respondent number 5 and 6. 6 is who? 6 is also Mangnia. 5 and 6. 5 to 6. The authorities, they have already dispersed.
Yes. That's why
Authorities have already dispersed the compensation in favor of the respondents.
yes, respondent number 5.
5
Only 5.
Respondent number 5.
Amount is also huge, my lord.
It is also, it is further contains that while acquiring, while assessing the compensation amount, for the acquired land, the respondent returns have not followed the mandate of the right to fair compensation, so and so, 2000 people. Issue notice returnable by 4 weeks. And Mr. And return with so and so and so. For, no problem notice. 1 to 4. Additional to take state services process application for 5, 6. Whatever 7. Mr. Advocate, so
It's up to this honorable.
will you stay up?
Oh,
Let it look. It's not proper. The respondent number 7, the name of the respondent 7. It states strike up in view of the fact that the respondent number 7 has acted was a concept for the parties that relate and form the fact and has no interest over on the events of the participants.
much.
Item number 5.
Yes, will appear.
Autonomous body.
You take steps, we'll consider and dispose on Friday. If you take the state,
Sure.
and Mr. But here also, Mr. Taru,
Minus.
you are in a wait list, you are a waitlisted candidate.
Yes.
If they appoint you, it's okay. Nobody's will be questioning, but legally, you cannot.
My lord,
You read the judgment of Supreme Court, Rakire and Ukul Sekia from our own item. Once that post is filled up,
my lord, my here question. I waited list. And
you have been
by
called.
virtue of,
You have been called.
yes, I have been called.
You have the negotiation.
Yeah, all amount are negotiated. And after that, I'm
For a-
waiting for some time for
How many months? How many months?
4 months, April. I was invited on
It's a regular appointment.
contract basis.
Okay, we'll see. On you take Dusty on, we'll see it on Thursday. And Mr. Tito, learn consent for the petitioner. This petition is quite. Secretary what? It's secretary of what?
For the post of secretary for Arunachal Pradesh
For Arunachal Pradesh
Electricity Regulatory Commission.
State Electricity Regulatory Commission. In terms of pursuant to the advertisement dated 27/09/2024. Mr. Selected. No, on the petitioner was selected. Best listed candidate. On the third of the selected candidate, the respondent authorities has invited the petitioner for appointment, for which the petitioner has appeared. However, even after lapse of 4 months, there is no consideration. Despite repeated approaches Issue notice. Return it in time. 2 days. 2 days. Suppose when it should take, just if they don't appear, it will be difficult to dispose of them. We'll say 2 weeks.
Direction, my prayer, direction may be given to the respondent authority to dispose of my pending representation.
Should notice. We will return it by 2 weeks. Then the council could produce that we take the steps, solution notice happen. The respondents, the registered persons, as well as by testimony, within 2 working days. It's the matter after 2 weeks.
One more here. Waiting after 4 months instead of that, my representation filed on April and IY negotiated on February. So February, March, April only instead of 4 months, kindly corrected maybe agent 3 months. IY invited.
3 months.
Yes. So otherwise it will difficult for the respondent because I have wrongly mentioned the months of.
Okay.
Highly honest.
Item number 6.
It's 145 proceedings.
Not maintainable manner. Proceeding that has been, apparently it was on 145 CRPC. So if they are agreed, they could have definitely approached before the
Yeah, please.
district.
Lordship, since the conducting council is out of station, it may be heard on her presence.
So we'll have to wait for him. Who is the conducting council?
Impertinent, sir.
Lordship, last time for reconciliation, it was suggested, we tried, but that also didn't
Not
happen.
happen.
So,
Yes, I've seen it.
yes, so definitely we cannot reject that. It should be heard today, Manala. But
A short date may be given, yes.
As agreed to by, no, and MS Swenson, the concept. Appearing on behalf of Mr.
Impertinent.
Impertinent, that is senior counsel. Submitted. Then counsel, then senior counsel. And some question difficult for which he pays work. Listing of the matter. After a week.
Yes.
After a week.
Yes. Much obliged.
They are not being objected to by then counsel for respondent. Mr. Peter.
respondent number 3.
No, then in that MS T Wang Mo, who is for what?
Public prosecutor.
And Mr. Peter Command respondent number 2. Same is allowed. Same is allowed. That they agreed to buy. That will be listed after a week. Yeah. Okay.
Item number 10.
My laptop in process. First one is almost has become in process. We'll hear the second one only. Because your the representation has been disposed of. Lordship is absolutely correct. Heard Mr. Imagine that when council, let's see, council, system back. And sir, in item 10, we're closing it as in process. Huh? Item 10.
Lordship will dispose of both the petitions at a time by the same order, my common order. That can be done.
First of all, section 64. Is it a acquisition under the 2013?
My lord, dispute is only very, very limited.
Huh?
Compensation has been given. Award is passed. Now
You have not been included.
I have not, I was initially included, subsequently removed.
Right to fair command.
No, my lord, it will be under,
Please proceed.
under the old act, my lord.
Yeah.
Under the old act.
Still then,
Yes, ma'am. My lord, what has happened, the issue is very simple. All these petitions before your lordship are female heirs of the original woman. Now the issue is, there is a society who says that as a female heir, you are not entitled to any compensation. However, by way of my lord, favor we are showing to you, we are giving you 20% of the entire amount. So we are deprived of 80% of our amount, whether that can be done. Now,
have you been given 20%?
yes, 20% they have
You have
agreed.
accepted the 20?
No, my lord, they have agreed to give me. We have telling.
Okay, you have not been,
No.
you have not been given. You have not been.
No, they have said they will give me 20%, but we are not happy with it.
Where is the award?
Award your lords will find. The award your lordship will find the first petition of 167, man.
167.
7.
167 means?
WBC 167.
Yes, that's where.
Yes.
Page.
Page 44.
Why the award was which year?
Of 2015,
15.
my dear.
Then why?
Well-
Why in 1894? Section 25 could have been involved.
Yeah, absolutely, man. Page
Anyway, you are not disputing it.
No, that is not the issue, my lord. Only
Section
issue is-
30 solution amount may expect against.
but if by the speaking order, the issue has been dealt with, lordship will kindly come to that. My lord, if I can't take up the second issue, there are two documents which your lordship will carry. First is the order passed by the Supreme Court earlier, by which, based on which the present speaking order has been passed, or rather the representation has been displayed document. The order is at page 23, my lord. Start from page, offer depart from page 25. Page 25. At the bottom, my lord, submitted that based on the materials available on record, for this work, my lord, page 25. It is submitted that based on the materials available on record, there is a serious objection from the society to the disbursement of the land acquisition compensation to the petitioners as their female members of the deceased father's payment. Accordingly, it is submitted that the petitioner's share of the compensation cannot be released to a third party. In the light of the above, the learned in the council for the petition submits that petitioners be granted liberty to file an appropriate application to impede the said unregistered society as one of the respondents at those instances of the petitioner's right to compensation is sought to be curtailed. Liberty has been granted. We have also heard Swenso. It may be mentioned that Mr. Swenso and counsel for the respondent of Port 8 has submitted that the issue can be sorted out by directing the Deputy Commissioner Dibang Valley District Anini to decide the representation submitted by the petitioner on 25/10/2023. Insofar as the representation dated 25/10/2023 filed by the petitioner before the Deputy Commissioner Dibang Valley District Anini is concerned, the pendency of the petition shall not be a bar for the said authority to dispose of the representation of the petitioner. However, insofar as the share
of the petitioners for compensation is concerned, the same shall not be disbursed to any third party. If any order is passed on the representation submitted by the petitioner, the Deputy Commissioner Dibangiri District Anini shall transmit a copy of the order to the learned senior government advocate for being placed before the court. Petitioner shall produce a separate copy of this order before the Deputy Commissioner. So thereafter, my lord, the order, next page, page 28, the order was passed by the Deputy Commissioner. May I read it, my lord? In compliance with the Guwahati High Court Itanagar bench ordered in WPC number so-and-so, I have gone through the representation submitted by so-and-so. As a matter of fact, the petitioner along with 3 other members, names are given, my lord, submitted a representation on 25/10/2023 to Deputy Commissioner Dibangiri District seeking inclusion of their name in the PAF project affected family list in MUD, LU and Azuri community for land compensation under Italian hydroelectric project 3097 megawatt. I have gone through the courts and land acquisition process of so-and-so, which is as follows. Government of Arunachal Pradesh issued preliminary notification under section 4.1 of Land Acquisition Act 1894 by notification number so-and-so dated 26 November 2012. Prepared and complete the under so-and-so, 2013, ultimately. Yes. 2013 Act ultimately. Yes, my lord. Prepared under, complete under 2013 Act because award was after the new Act came into force. And the approved by the government on so-and-so for so-and-so, it is so-and-so. It is evident that, but this is the decision. It is evident that the entire land acquisition process against Italian hydroelectric project 3097 megawatt has been completed and there is no scope or reason for inclusion or deletion in the list of project affected family. Opportunity for claims and objection was kept open to all the interested persons, parties and public notice to this effect was issued by the Deputy Commissioner, Collector under Section 9 of Land Acquisition Act 1894. In addition, Deputy Commissioner in the capacity of Administrator for Relief and Resettlement also invited claims and objections from all the persons likely to be affected along with the findings as per the baseline survey conducted in the affected areas by issuing notice under State Rehabilitation and Resettlement Policy 2008. There is no record or evidence that the petitioner has made any claim. No, basically rejected on the ground that you have not made any claims and objections at the relevant point of time. Yes. Notice was issued. Yes. They have not issued that whether you are entitled or not. Yes. Now, so, who will decide? It is the Deputy Commissioner. Collector has to decide. Collector has the entire authority. Collector has the authority to decide everything. One thing is maybe is that, but then if you have not filed any objection when the notice was issued. I have raised the objection that I am entitled. And when at the relevant point you have to. My lord, land acquisition is something which cannot be denied to a person only because there was a delay. No, it's not a question of delay. My lord. You have not, when the notice was issued, published, my lord, for claims and objection, you have not raised any objection. My lord, our Deputy Commissioner who cannot change this now. Our allegation is our names were there initially. Subsequently, it has been removed. By whom? By these persons, by society. Society wants, my lord, here the Deputy Commissioner has not dealt with the real issue. The real issue is the society who has filed an affidavit saying that, see, these are all female members, they are not entitled to any compensation. Anyway, we have decided to give them 20% of the compensation, and that is the issue. It is not the issue that we did not raise objection at the relevant point of time. No, but the facts remain that you have not raised any objection. At that time, we did not know that our names will be removed subsequently. We have. You show us that at that time, public notice. Even, my lord, for the time being, my lord. After the public notice, your name was there. My lord, let us see. My lord, anyway, my lord, even assuming your lordship ultimately comes to a finding that at the relevant point of time, they did not raise any objection. Can they be denied by compensation on that? No, it's not a question of denial. We'll have to have a right also. But right, you have to follow the procedure. When you say that the collector has not followed, you are equally have the duty to follow that also. My lord, suppose the public notice is given. My lord, is it not required to give your claims and objection? My lord, that is why I am. So that's why when you say when there is a public notice, your name was there. They were there. So us.
My lord, I'm coming to that, my lord. Lord, will you kindly see one thing. See here, my lord, Lord, will you kindly go, what is the dispute? Dispute is we are sought to be deprived only on the ground that our father did not have any male member.
Understood, sir.
My lord.
We'll come to that. First,
My lord.
we'll clear this.
My lord.
Whether your name was there or not.
My lord, our name was there, we have specifically mentioned, there is no dispute about that. Lord, will kindly have a look at page, my lord. This affidavit we have annexed, it's not very clear here. I'll read it from here, my lord. The earlier petition, Lord, will kindly see the affidavit. That is the basic reason for depriving us, my lord. Lord, will kindly come to page 52 of the WPC number 167, my lord. 167. Page 53. My lord, on behalf of AAP, there is a society who is fighting and they are saying that we'll give you only 20%. It's not that we have not raised the objection at the relevant point of time. Page 53, my lord.
This is very the right of the.
My lord, I'll show your lordship one judgment, my lord, which says on this ground a tribal lady being a female was sought to be deprived. What is the ratio in that case?
Where it is.
Page 53, my lord.
53.
My lord.
Affidavit.
My
I
lord.
mean, this.
This is the basis for our denial. NHPC Limited so and so, and next paragraph, my lord. Whereas the state government issued notification number so and so under section 4(6) of the Land Acquisition Act 1894, respectively for acquisition of subject land or properties for a public purpose, for Divangveri, multi-purpose project, etc. And whereas the representatives have been authorized to execute the present agreement on behalf of the members of the ELOP committee by resolution number so and so, November so and so, appended so and so. So they are, we are represented by this society, madam. Not that we were not there. By resolution number so and so, declaration by 27/11/2021 to this agreement, whereby representative has been authorized to perform the acts on behalf of the community, such as receiving of compensation amount from the state government against the land and assets. The details of such land and assets under possession of the members of the community who have authorized the representative is appended as Schedule A to this agreement. And whereas the Deputy Commissioner, Lower Divangveri District, passed an award as approved by the government dated 22nd February 2019, determining compensation for the aforesaid acquisition. And whereas user agency, that is NHPC Limited, being agreed by the award, challenged the award approved by the government in WPC number so and so before the Itanagar bench of the Honorable Guwahati High Court. And whereas to avoid any delay in execution of the project of the national importance and in pursuance of the Honorable High Court order dated so and so, an amicable settlement was arrived at between the state government of Arunachal Pradesh, the representative community, and the user agency NHPC Limited on so and so, to the effect that the compensation will be calculated and accept on mutually agreed parameters which were appended to the minutes of the meeting dated so and so. And whereas in view of the above facts, the Honorable High Court by order dated 1/11/2021 has observed that it is of considered opinion that there would be no embargo in disbursing money to parties who are not a party to the requisition or any connected matter thereof. And whereas on the basis of the mutually agreed parameter, the compensation payable to the members of the community through the representative has been determined by the state government of Arunachal Pradesh and agreed by the NHPC Limited and the community. The same is appended as Schedule B. And whereas representative has on behalf of the members of the ELOP community accepted the compensation payable as per Schedule B to this agreement. And whereas an amount of rupees so and so only has been paid to the representative by check number so and so by the state government and accepted and represented by the representatives on behalf of the ELOP community. Now, therefore, in consideration of the premises and mutual agreement and covenants contained in this agreement, each of the parties hereby agree and conform as follows. The first few paragraphs we can skip. Lordship may kindly come to the page 55, my lord, the bottom paragraph.
The agreement between whom?
That is DC and whom? DC and the society, my lord. That is the issue, and that society has been representing all the persons who are entitled to compensation. We are also being represented by the society. Now the society says,
Says page 57.
my lord. Yes. Page 57 is the signature of the person, my lord.
Who are they?
These are the persons, my lord.
They are also lady.
Yes.
So,
Page 52, if your lordship peruses for a moment, one page document, this will clinch the entire issue. Page 50. This is written by that society to the deputy commissioner. Ma'am. Page 50. One page document will examine the whole issue. This is the basic thing. With due sense of dismay and sorrow, we, the undersigned, would like to bring forward some point before your highness. And with regard to the above mentioned complaint, since the inception of the village committee members and adoption of resolution in the year 2012, we had adopted the resolution and the same was verified and signed by the executive magistrate, so and so, and the same was also circulated within all the village community members. Since then, there had been no any complaint regarding the existence of that resolution. However, it is disheartening to learn that some of our own sisters have written before your kind self for the inclusion in the list of PAFs in village community level community, stating that they do not have their fathers or brothers, whereas it is pertinent to inform your good self that in affidavit bearing number so and so, we have already observed, we have clearly reserved 20% of total compensation amount for the female community, including sisters and widows of the community, and there is no any scope for the resolution. However, on 11/12/2024, a general meeting was conducted at so-and-so village, where all the attending members agreed upon the deletion of any deceased member in clause 9 of the resolution number so-and-so, and in this regard, we might even claim to have jotted down for being the first village level community to have reserved specific percentage of amount of female members in affidavit in whole of Dibang Valley district. Therefore, it is to inform your esteemed self that complainant
so community has already received the amount.
yes,
So
this
you-
community.
You find a.
No, money has not been disbursed. It is lying with the deputy commissioner. My lord, here is a case. Lordship will kindly consider one thing.
They have.
My lord,
the
your-
community has agreed to be represented by some persons.
My lord,
In the resolution.
my lord.
Community.
No, my lord, if the
Was part of.
my lord, I am entitled. My lord, I am entitled. My lord, land acquisition law is slightly different, my lord. I am entitled to my compensation. I have annexed one judgment of your lordship, my lord, this one go, which says that all individual members are entitled to his part of the compensation. I have annexed. Now,
You have agreed that they should be by the community.
True, my
On
lord.
Your own convenience, it's a community land.
my lord, if the my lord, I have
It's a community land and individual land.
community land, my lord.
Community land,
Yes.
community
My lord, if the
can be represented
My
by
lord.
community.
my lord, if the
Sir, if it is a individual land,
my lord,
individual right, then. Okay.
lord, I'm-
You may be correct.
my lord, I am
The individual has to pay at their own.
my lord, each individual is entitled to his own compensation in this case, my lord. Each
So if
individual
it
is
a community land, how?
or my compensation is different. All the petitioners have got different compensation, and each and every member of the entire my lord area has been given separate compensation.
Then how much were entitled?
My lord, I am an individual. My cousins have given a share. I want equal share.
So they can export it and
My lord, I am entitled to equal share. My only prayer before Lordship is I'm entitled to equal share. And because,
out of context, instead, like other things.
madam,
Cousins are equally a bad assistants. And brother is a cousin.
my lord,
But they are more than
not,
like
not through my father, my lord,
my brother.
not through my father.
Cousin,
My father is entitled to
I'll
compensation.
give you my own example.
No, well, my,
Really,
no, madam, madam, factually it is slightly different. What I'm saying is here,
no, it's
madam, I'm,
so,
my-
so cousins, it really, I'll take chance. I'll give my own example.
Fine.
My real younger brother, excellent cousin.
to the same,
What should we make it private? What should we brother?
madam, here,
Doesn't make said father.
no, madam, here,
Yes, doesn't.
madam, here factually slightly
And
different.
I've been born and brought up by my uncle. My all, I don't know. I know that my real father had very good father and mother. And that went to my mother.
Yeah.
Whom I consider my father and mother.
Yes,
My father's elder brother.
yes,
I born
these children.
no.
Hmm.
I my father, my father. Born and brought up by my uncle.
Uncle needs.
From the day, only all people got by my father, father, born and brought up
By them,
by my uncle.
by him, dear Lord.
But I consider it's not a customary extent. Here my father-in-law, educated,
They have raised your Lord.
my, so my brothers, cousins, actually, they are not travel. Brought up, so my actual, I mean, biological father,
I know that's
they
it.
unfortunately, they have expired, they still. I consider that is still my father's father.
Absolutely, my lord. It happens. Well, even in our society, even
It's not that I am our
Right.
Equally my father.
like parents. My lord, these, right? In our society also same thing.
So what I'm trying to tell you is that in a tribal society, cousins and all these things, in fact, it's not counted in the blood thing, relation. In fact,
Here it is like different.
so it's a relation
But,
you
my lord,
maintain.
what your lordship is not,
Cousins can be equally your
no, my lord, that
as
is,
good as your real blood.
my lord, that is not the case here. I'm
Ah.
trying to lordship kindly bear with me.
Yes.
Here is a case, my father gets a share in the of the compensation. That has not been given to me because I am the only child of my father, because I don't have any brother. This is the case here, my lord. It's not a case here that my father's son has got and I am not given. No. My father's share, which I am entitled.
No, that again, sir, will again depend on your customary and traditional. I mean,
That is
it will be regulated.
exactly, my lord. This is what I'm saying. They are saying that under the custom, a person who doesn't have any male heir, the female heir is not entitled to anything. And my submission, I'll do one judgment of Supreme Court, my lord. Supreme Court says in such a case, particularly in a tribal society, unless you can show some customary law, you cannot deprive a tribal lady. You have to show. You are saying that there is a custom. You show that where is that custom which says that a person, if he doesn't have a male child, his female child will not get anything. Where will his property go then, my lord? Supposing a person has a property and he doesn't have a male child, there cannot be any clog in the succession of his property.
That is the
So in that case, female will get. This is my submission.
no, that is a set part in the system prevailing in
Yes,
this part of the country.
exactly, my lord. That's what I'm saying. A person, if he doesn't have any, assuming that there is a
That's
custom,
why that is the saddest part, and it is unfortunate that custom is being prevailed in the part this part of the country.
my lord, my lord, my lordship will tell you, bear with me. What I'm saying is, my lord, if under the custom, a person has got 10 children. Out of that, there are 3 female and rest are male. And the custom says that only male members will inherit. Female will not get. That can be understood. But in a case where a person has got 2 children and both of them are female, what will happen to the property of that man, my lord? Can we say that no, it will not go, stop there? That is why the Supreme Court says in a tribal society, a person who is trying to deprive a female child on the ground that she is female, you have to show that custom. And in that particular case, when the Supreme Court says none of the parties could show any custom, and therefore the female legal heir cannot be deprived of a hard share of compensation. And one case is when land acquisition. But you kindly see it. When the issue is this issue, whether the person who doesn't have any male child can be deprived of the succession to the female child. That is the issue. Madam, 2023 3 SSC 528, madam. Parties names are Kamla Neti. Madam, there are 2 judgments which I have given, madam. One is, madam, 23 3 SC Kamla Neti, madam. Can you pick up the 2025 SCC online FC part, madam? From there, I'll there are 26. Yes, madam, I'm really first referring to this 2025 Ramcharan. 2020. Yes. There are 26% candidate. There are 26. There are this discussion on equality under Article 14, which needless to state, includes the aspect of gender equality within its core will be, in our view, incomplete without reference to the first and most commendable step taken under the Hindu law by way of Succession Amendment Act of 2005, which made daughters the co-personers in joint family property. The object and reasons as stated in the bill are instructive in the general sense, and we reproduce the same profit. The law, by excluding daughter from participating in the co-personal ownership, not only contributes to her discrimination on the ground of gender, but also has led to the oppression and negation of our fundamental right of equality guaranteed by the Constitution. Having regard to the need to render social justice to women, the state of AP, Tamil Nadu, Karnataka, and Maharashtra have made necessary changes in the law, giving equal right to the daughters in Hindu Vitakshara, co-personal property. The Kerala legislature has enacted the Kerala Joint Similarly, we have the view that unless otherwise prescribed in law, denying the female heir a right in the property only exacerbates gender division and discrimination which the law ensure to weed out. Granted that no such custom, this is my submission, madam. Granted that no such custom of female succession could be established by the appellant plaintiff, but nonetheless, it is also equally true that a custom to the contrary also could not be shown in the slightest, much less proved. That being the case, denying so-and-so her share in her father's property when the custom is silent would violate her right to equality vis-a-vis her brothers or those of her legal heir vis-a-vis their husband. The Honorable Supreme Court says that yes, I'm unable to show any custom, but you are also unable to show any custom that female heir can be deprived. There is no written law or custom or usage. Of the above
Which one that? Shipment of the.
That is what I'm saying. If your lordship, my lord, permits me, I'll show.
You file an
Under the-
application for reference.
No, my lord, under the law, if there is any dispute about the apportionment, it is DC, my lord, lordship, kindly see section 30.
No, GC has rejected only for inclusion.
Yes. In that case, if there is a dispute about
You file
apportionment,
a reference application, let the DC refer to the reference court.
no, my lord, if there is a dispute about the apportionment, the authority has to refer it to the civil court. Civil court will decide who will be entitled. If your lordship says, my lord, we'll have to go to the civil court. Then your lordship will refer with approach for the parties will go. No,
We'll have to go.
no, my lord, compensation is still lying with the deputy. This honorable court has stopped. Compensation is lying with the deputy. It has not been disbursed. It cannot be disbursed, my lord. Only after civil court decides who is entitled under the law, then only the compensation will be disbursed.
Provided how much share that then? How much?
I am claiming that as a heir, I am entitled to full share, my share.
What is your share? Tell us. Say if it is 100 rupees.
Yes.
It's a community land. You are not able to show that it's your individual land. You said your father was the community, you are the landowner. What is your, how many percent you are? How many they are in your community?
My lord, society, lordship has seen.
Society, how many people?
Society, my lord, society has
How many members, sir?
Lordship, kindly not put the burden on us.
Yeah.
The entire process has been done in such a way that I am unable to give your lordship the data and figure. The society has done it, my lord. And the deputy commissioner should not have entertained the society. Who is the society, my lord? Under the law, society has got no recognition.
See, it's okay.
My lord,
It's maybe it's not, see, we cannot compare.
Unfortunately, my
See,
lord.
we have seen all these things.
Lordship is correct. Unfortunately, it happens.
There are areas where strict kind of procedure cannot be followed. Ultimately, it's important. But it's,
Yes,
see, there's the function of community.
plain areas, yes.
And the dispute regarding individual ownership. There's no so that we can so that one of the
Right.
Yeah, so in some cases, it's not the violation as such. There can be some aggressions.
No, some, but I am not on that. Slight aberration, your lordship is absolutely correct.
Just cannot say that if it's a community land. Yes, strictly they don't have the.
My lord, your lordship is absolutely correct.
Yes.
My lord, here that is not the dispute. Slight aberration here and there.
Yeah, if you are, if
No,
you are, if you are,
My lordship is
that's why I said.
possibly I have not been able to convey to you.
No, I've understood.
My lord, here there is no difficulty with this slight aberration here and there. Here the difficulty is they themselves are saying that you will be given 20% of your actual
Okay,
share.
now what is your, what?
100%.
What
They know that. I mean, they have said 20%. Let them remove the tag of 20%. I'll be happy. I'll go back, my lord. They themselves are saying restricting my compensation to 20%. That your lordship will kindly decide whether my right can be reduced to 20%. That is the issue with your lordship, man. I, as a lady member, my lord, I got that. Yes, my lord.
Whether it is objection to the measurement of the amount of the compensation, question to whom it is paid. You are saying that.
That is,
That's also,
Yes.
why only the company.
absolutely, man. But,
Provide you.
yes. Because that authority will decide. Authority will decide as to how much of amount I am entitled.
You are withdrawing.
Now, my lordship will kindly observe that. No, my difficulty is mere withdrawal, they will disburse the compensation. That is not permitted under this Act of 2013 also. Until and unless that is done, it cannot be released. That your lordship will be ensure. No, my lord.
Collectors, you have.
No, my lord, I'll approach. My lord, in the meantime,
You have to approve that.
my lord, I'll approach.
Collector.
No, moment I raise the objection, collector has to refer, my lord. And lordship will kindly
Section, yes, collector has a rejection of your application. Nothing wrong there. No,
my lord, collector.
Deputy Commissioner, what Deputy Commissioner has said is that there was a public notice for claims and objection. You have not come forward, therefore we cannot accept your, grievance now. That's the only ground.
My lord,
He has not said any, or else you have not asked for reference of the, your grievance. You have not filed any application for reference.
lordship will kindly see one thing. Lordship will kindly see this section 30 of the old data. I just pointed one. Then they
No, this will apply now.
No, this
Because
will apply.
ultimately award was completed
yes.
under this.
Yes, my lord, what I
Let us not go back to that.
all right,
Section 60.
my lord. My lord,
Better
my lord,
withdraw will give a liberty in view of the
then I'll, my lord,
provision of section 64.
my only application, once I withdraw, the amount will be disbursed to them. That your lordship will have to protect, my lord.
When someone is to withdraw, it's very difficult. You make an application. You show the law to the.
My lord, the society which
DC has not said that I cannot infer it. Only what he has
my lord,
rejected your application is that you cannot be included because there was a wrongly or rightly the public notice was claims and objection notice was published. You have not come forward. That's the only ground. He never said that I cannot refer.
my lord, I'll satisfy you.
In fact, you should have approached the collector for referring it to the under section 64. You have not done so also.
My lord,
You have not done that also.
my lord, when I have raised this objection that I am entitled to this much, while rejecting, whether that rejection on the ground that I did not raise the objection was right or not, that your lordship will decide. Because, my lord, if your lordship goes to section 64, what the authority has, the collector has to decide is whether I am entitled to the full compensation or not. The authority has said, no, you did not raise any objection. Is that decision correct, my lord? Lordship will kindly consider. The authority has not decided on merit that under the customary law, I am not entitled. Had the authority decided under the customary law, I am not entitled to full amount of compensation, then I should have taken the normal course. My only submission before lordship is authority has not acted in accordance with section 64. Assuming that my application was there, that I have raised the objection that I am entitled to full compensation, my right cannot be restricted to 20%. In that case, if your lordship says that authority has rightly or wrongly decided, then lordship will, I am before your lordship challenging that order. Lordship will kindly see whether the authority has taken a decision on merit or it has simply said, no, you didn't raise any objection. Land Acquisition Act 2013 also doesn't say that if you do not raise the objection at the proper time, you will not have no claim.
That's why I'm saying we'll give you a liberty. If we go into merit, we cannot, condone the delay. There's a, time limitation is there. 30 days, 60 days.
Yes.
You have not filed any reference which you ought to have done.
My lord, I have already approached.
That's why I'm saying, I'm indicating, sir. I don't know, you better know. I'm indicating, if I decide on merit, of course, prima facie, I'll be dismissing the writ petition. Those doors may be closed. I don't know, I'm not saying that appeal, you may go to appeal. But so far as single bench is concerned, there may be a problem. So that I don't want, because ultimately what will happen?
Then,
ultimately, because under the law, there's a limitation is provided. You just cannot condone like that.
My lord, lordship is aware.
If we allow you to withdraw the writ petition with the liberty to approach, the appropriate collector and the the reference authority will consider all this thing.
My lord, I can withdraw this with liberty provided your lordship protects me to the extent that compensation amount will not be decided, will not be disbursed. Otherwise, nothing will remain, man.
So once I allow you to
Then lordship will give me some time and I'll set by your lordship.
that's all I'm on. That's no matter. Matter is very simple. You have simplified very small issue.
But yes, but issue is very small. Issue is only small, my lord, that
But ultimately, after hearing you, you have simplified. Very nicely. Simplified it. I have understood. Thank you.
reference I can go, my lord, there are cases where the Honorable High Court in principle, the lordship is also has given the liberty to go by condoning the delay that they under section 18 reference will take place now. But then liberty is given so that the delay that has occurred in the meantime doesn't come in the way, number one. And number two, disbursement is not permissible under this law. Deputy Commissioner.
The non-disbursement of the compensation will have very bearing and effect on the construction of the Adipur.
No, it is going on. There is no, it will not affect. It's a dispute between the private respondents, two private parties, by now.
Yes, sir, what you say?
No, my audit pen has not pointed out so project affected families. They only got the benefit project affected families. My lord, your lordship has asked a pertinent question whether you can show before the court that your father's name exists at that relevant time. My lord, he did not produce one particular document before the court, and my learned friend is putting a burden that we have to show. Deputy Commissioner, he has not shown any of the document. No claims there than claims which the Deputy Commissioner has invited. Objection has been invited. Not a single objection he could file. Only after everything was done, he comes to the court. And one difficulty what I found, subject to lordship will correct, 64, reference to authority is only any person interested who has not accepted the award.
Not only that.
There has to be an award. Kindly see, my lord, page 64, reference to authority. Kindly see the first 64.
Yes.
Any person interested who has not accepted the award may by written applicant collector require that a matter be referred to the determination of the authority as the case may be, whether is objection to measurement of the land, amount of compensation person to whom it's payable, rights of rehabilitation resettlement under chapter 5 and 6 of the appropriation of the compensation among the person interested. So here, my lord, there was no award. If there was an award, he or she has not accepted the award, then the question of reference to the authority will come. Here, with great respect, I'll say that there may be a difficulty in section 64 because it only says who has not accepted the award. There is no award which was made.
The compensation under which law?
No compensation.
Under which law?
Award not in respect. Award is under the new particular 2023 Act. The award. Yes,
Yes.
23.
Then,
Yes, 2013 Act.
then sir, why you are saying that there is no award?
No award. There is an award. But this, so far as my learned friend is concerned, his name is not there. First,
You have really got it deleted.
no, I didn't get deleted, my lord. It is not that I got deleted.
I am a member of the committee,
I didn't get-
admittedly.
He
Person interested in the definition is two, I think, three, common,
yes,
career.
my lord,
All person claiming a
My lord,
compensation
projected-
on account of the acquisition of the land.
my lord, only project affected families are entitled. Secondly, for the purpose of
Then why they said? why they said
resettlement
you-
policy.
you Provide them 20%. On what basis?
No,
20%.
not 20% on a moral ground we said we'll give it.
Then
On a moral ground we said we'll give it.
you extend another 80% moratorium.
No, if you willing, let
So what I'm asking is, will allow them to, let me can then allow those approach the liberty to collector by section 61 for reference to the authority. Yes, right. Till it is referred. Till the order is passed
By the authority, by the authority. Well.
So disbursement.
Yes.
Yes, so.
no, that is what I'm saying.
So that,
He can file a,
the authority can pass.
no, he can pass appropriate order. He can make an application there itself, my lord.
Yeah, that's why.
Let's let him file.
Yeah,
Let's-
interact them.
No, intergram, my lord.
The interact them. Say the cost is.
No, that's up to the court, my lord. But he can
No,
file
I'm
an.
just asking, sir, this.
My lord,
I have two options.
He said dispose of.
I have an option. I may dispose of and pass a printed order. Or instead of going into it, for the convenience of all, I say, I'm inclined to, the dispute the expedition, but you have to approach the, better to refer it, if you are liberty. What is saying that, the agreement to that, but then should not be destroyed. Till the appropriate order is passed by the reference authority. Or till the approach. If they approach the reference authority. Then definitely they file an application.
My lord, Lordship may kindly support
Depends.
section 76. I
Some-
think more appropriate provision is section 76. Is a more appropriate. The exact dispute here is about apportionment. Section 76, man. When the amount of compensation has been settled, if any dispute arises as to the apportionment of the same, or any part thereof, or as to the persons to whom the same or any part thereof is payable, collector may refer such dispute to the authority. So it is for the collector. Once I have raised the dispute, collector is to refer it to the authority.
You have to raise.
My lord, I have raised it.
This is they have not
My lord,
raised.
My lord, I have raised. My lord, Lordship, kindly bear with me. What has happened?
What
In
you
the-
have said is, are also the honor or the daughters of the forefathers, mothers, who doesn't have the marriage to. Therefore, were also entitled, therefore, my name should be, our name should be included.
No, no, no,
Yeah,
my,
list of-
no, my lord. My lord, what has happened here? My lord, our names were there. My lord, all records are not before the, our names were there. Subsequently, names were removed from the list of project affected family. Then we approached this honorable court and we filed a representation. This honorable court said you file a, let the representation be disposed of. while disposing of representation, my lord, when the society wants that we should be deprived on the ground that we are female, the deputy commissioner has taken decision that no, since we did not raise the objection at the appropriate time, we are rejecting. Now the question is, my lord, the fact that we are a part of the community is admitted. The fact that community land has been taken is also admitted. What remains is that they want to give us only 20%. We say that full share should be given to us. Now this is a dispute with regard to only apportionment and nothing else. When we have raised the objection, this Honorable Court directed the Deputy Commissioner, my lord, to dispose of. Deputy Commissioner, instead of disposing of, should have referred it to the authority. Now the ball was in the court of my lord, Deputy Commissioner only. Collector. Collector has taken a decision, my lord.
Collector has not entertained his application. Collector
Collector has no authority to reject my petition. Collector has to only see what is the apportionment. Collector has got no other business. About my lord, about determination of right, it is the civil court, not the collector. My learned friend is wrong.
Go for a civil court. Your writ petition 212.
My lord,
Your application. Is 50.
page 30. Yes, ma'am. So this, we have raised it. Yes. My lord, second paragraph. Yes. Second paragraph. In spite of inclusion of our name in the projected family list during the enlisting of named family members to PF list against the projected so and so, community members have been deserted. So we were there. It's our claim. My lordship, kindly see the statement. In spite of inclusion of our name. My lord, they are not disputing it. My learned friend, lordship, let them show one affidavit where they dispute that our names were originally not included. There is nothing.
When you say that it's better to do the.
Yes.
What does PF?
My lord, this is not, my lord, I'll have to establish only when they dispute. They do not dispute.
During the enlisting of names, family members to PF against the protection. What no, this is what they are trying to say. They were included and they were enlisted by.
Yes. Originally, when enlistment was there of the projected family, the authority, my lord.
No, that is enlisting of family members of against the protection. Our committee members have deserted us.
Yes. So subsequently, when a list is prepared, community members through the society have gone there saying that no, these are female, they don't have any male child, so deprive them.
They don't have any discovery here.
But
That's
maybe,
what I'm asking.
maybe,
Don't have this.
my lord, maybe it is there, my lord. Maybe it is there. I'll have to show my.
Is 30, which your lordship is reading. First, we are the only 4 daughters of our fathers of so and are born and exist as on today. Our father died 20 years back, and we have to follow our widow mother from one place to another for our sustenance at a very early age. Somehow, as on today, we are married and living in the place of our spouse. Hence, we are only surviving bloodlines of our fathers a rightful claimant over excess
Father
debt.
claim. So father has the right still.
People are staying in a some.
When father expired, father still has the right. And father's share we are claiming.
And they
Can we be
not
deprived
see.
on the ground that
And
we want
what we are
object in
saying
the appropriate
came
time?
to light, we have checked the PF list. Where is that PF list? Recently checked the PF. Where is that PF list?
Okay,
And my lord, one more aspect.
that's all.
One more aspect, my lord. My lordship will refer us to the 65 or 70% is the appropriate provision. We'll go to the authority, or your lordship may say that collector had to refer it to the authority. Under section 76 is the collector. We have filed the representation before the collector. If the collector thinks there is a dispute with regard to apportionment, under section 76, collector ought to have referred it to the my lord, authority.
Yes. If you withdraw the writ petition,
Then your lordship will refer. I mean,
I'll allow you to give you a liberty,
but my lord, only one thing, my lord, please.
or else I'll pass the order.
No, my lord, our compensation amount, my lordship will kindly direct them not to disperse. Then we'll go by, not difficult. But once the compensation is disbursed, my lord, nothing will remain.
That will be on the agreement when you withdraw.
But-
If they.
My lord, my lord,
I'll
my
declare
lord,
it down.
you're-
But if you want me to decide on merit, I'll pass the order.
no, my lord, I am saying I will go.
Which way go, I don't know.
My lord, we'll go, no difficulty. Only thing is, my lord, lordship will direct them, the deputy commissioner not to disperse. Because once it is dispersed, your lordship will
Don't say
authority.
sorry.
Then at least 15 days time may be given, my lord. All-
You will direct it.
My lord, my lord, 15 days I'll approach the deputy commissioner. Till then, lordship will kindly direct them not to ask this. All right.
Withdraw.
No, my lord. Lord,
Then withdraw or I'll pass the order.
that's liberty, your lordship.
My quick wants an order by not withdrawing it. You want that your lordship
No,
pass an order, not withdrawing.
My lord, I have no.
Ultimately said you require it.
I-
And this is why I said drop it. Writing more to document and all this.
No, your lordship.
That's why I said.
My lord, yes, I am withdrawing.
ultimately, the job gets benefit. Said 15 days delay for you. So that you of
15
the,
days, and 15 days they will not disperse.
Oh.
Yes,
yes,
that
job
of
is
them.
dispersed. If it's not happening, I mean, doesn't have any, it's not affecting or affecting construction. Working is going on. Project is going on.
Yes, yes, ma'am. Project
Work
is
for
going.
what? No, your plan. That's what.
My lord, he
Work is going on. Project is going on.
no, you will be able to say.
No, they have not taken over the land. What is the instruction of my instructing council? They have not taken over.
Well, I think project is going on. Well, I have to take it. Sir. I think project is going on.
Our, there are.
Well, I'll find out work for.
Our land has not been taken. That's
Anyway, he wants to withdraw.
he wants to withdraw.
But Mr. D. Majumdar, that is senior counsel, assisted by. So it's a learned counsel for the petitioners.
Well, I'll just find out whether the project is
Yes.
going on or not.
Anyway. After arguing the matter at some length, Mr. Majumdar, that is senior counsel, clearly states that he may be allowed to return this, what is writ petition.
Madam, may I
In
submit?
view of the,
Madam, just,
in view of the provisions.
my lordship will kindly give me at least 10 minutes. I will find out whether withdrawal, some, one instruction will be necessary. Otherwise, the question will come whether they agreed for withdrawal or not.
So the question of the,
Lordship will give me just,
I'm suggesting,
my lordship will give me 10 minutes. I'll just find out. Just, I'm not asking for any adjournment.
yes. Next case.
Item number 13.
Why not, there is a subsequent development, in fact, the rule has also now been changed. This is the police cases. Take some instructions, my lord.
For closing.
No, my lord, take instructions, because there was a case, my lord, they had advertised some post, which we understand to be promotional post.
Yeah.
There is a protection for the honorable court, that the post that is reserved for us could remain as promotional post, But now the rule has also changed. I don't know what has happened to this code.
Rule
I
is
think
also, rule is still, further different rule.
different rule now. The
So it's
percentage,
not 50-50.
no, the percentage has come.
Mistake, deep on learning concept. Submits the. It may be done the first for some time to obtain instruction. It will, there is a subsequent development in the method. And it's stretching the cost. State boxing is present. Therefore, this method.
Item number 14.
I'm appearing on behalf of Taisi.
After 3 weeks time granted to file. You are. After 3 weeks time is granted to, on the prayer of MS. P. Sangeeta Alan State Council, further 3 weeks time is granted to file affidavit in opposition. Mr. So-and-so.
Item number 15.
Yes.
Better minor pleading of action has been communicated. Hearing may be taken.
Mr. We take a concept for the petition.
Yes, my lord.
Submit this. No. It's still, it is something about that meetings are completed. Mr. Metro for admission.
Yes, my
After 2 weeks.
yes. Of that.
Item number 16.
Madam, earlier on the January 2025. The petitioner, Madam, informed this reported that they're likely to withdraw the matter, Madam. And next date, Madam, this matter could not reach, Madam, at the possible time. So, as of now, Madam.
My lord, actually, after filing of this petition, 2 vacant posts has arisen now. So, and the department is ready to concede, but due to pendency of this writ, they are saying they could not consider. No, just pendency of the risk may not be bar for considering my case. That much observation exists. Yes, sir.
You have not filed.
Madam, not yet further, because at the earlier occasion, they were, I told Madam, I have the impression that they will be withdrawing, Madam. They made a submission before this order report that they will be withdrawing. That's why, Madam, because of this,
Only that much observation, my lord. Because if I withdraw, they may not consider my case. In that case, again, I have to come back.
Yes, so you come back because they don't. continue.
Or else also I have right,
Why?
because my junior has been promoted to DAO.
What is the matter? What you are challenging?
I'm challenging the promotion to respondent number 4 and 5.
Not to set. That the left constant for the petition. But that's, no, office note, then it is the way to. But it's the. Service is only mistake of this.
My lord, at least that observation, that may open the way for them.
Well,
My lord, there is already 2 posts. My lord, 2 vacant posts is arisen now. Department is willing, but because of this. Okay. Item number 17.
Your Lordship, I'm here for the private respondent.
yes,
We have to file affidavit in opposition.
yes.
Yes.
What has filed? Okay. Or this is so and so. No, no, said Yes, sir. For the prayer of Mr.
No, your lordship, I am put it exponent here. Yes. My name is Dia M. Kham.
Spot number
5678.
567. And 8. Praise for an instructed position. So and so are present.
Item number 20.
Withdrawal will be slightly difficult, possibly. Side on merit. Fine.
You right, huh? I think.
10 and
10 and 11. Not Mr. Huh? The budget difference. You have to pay, huh? One,
2 and 3.
one, Mr. Wait. That is the one. That's it. That's your consider assisted by eyes. Spot out.
I'm relying on two judgments you are considered.
Consider that.
Lordship will I think consider one thing that their share in the property is not disputed. What they think the authority,
Go by what is your preference?
my grievance is that
They open the
my only
upset the customs and tradition. It's not the issue. They are not saying that you are not entitled.
yes, that's what my submission.
You are not on that. We
Fine.
not venture into all this.
Madam,
Very, very sensitive.
my lord,
We decided in a way.
they are not saying that we are not entitled.
Then matter is that you are not entitled.
My lord, they are saying that you will be given only 20%.
That's why it's not civil court. They are saying that you are entitled, but they are giving you a lesser share.
Yes. Because I am female here.
I am entitled to do this.
My lord, lordship will kindly consider one thing, my lord. I leaving it to your lordship. They are saying that as a female heir, we are giving you 20%.
So what?
Clearly not there. They are not saying that we have got a custom. See, this is the custom.
They are not saying that you are not entitled. Fight it out in the civil court. I am also entitled.
My lord,
I'm entitled to this amount.
my lord, section 76 says it is the collector who has to refer it to the authority, my lord.
Yes, you have to say it.
My lord, I have to raise my objection. I have raised it, my lord.
Apportionment. What you have raised it include by name. That's all.
My lord, authority,
What
my lord,
the commissioner has said is, what you have become Mr. Police. I said, again, public notice for preemption objection.
you have,
You have not made any preemption objection.
my lord,
Go on.
to that
I
extent,
cannot-
my lord, to that extent, my lord, there is a environment lord will kindly consider that we were not aware when they have made the final list and they are not.
We are married. Staying in other places with happily with a spouse.
But land belonged to my father.
Once you got married,
My lord, my land belonged to my father.
you'll be assimilate with that with your spouse represent customer. Be happy there.
My lord, they,
Why disturbing
my lord,
credit?
on that ground, my lord. No, my lord, on that ground, my lord, on that ground, lordship, this is very important. They are also residing elsewhere. No, my lord, they are also residing elsewhere. My lord, I have got full confidence in the court.
This is not required.
My lord, I have got full confidence in the court that the court will take a fair decision. My lord, they are also residing elsewhere.
In that case, judgment reserved.
Yes. Judgment reserved. Lord will consider.
I thought I'll say this today. I'll get this today.
My
Item number 20.
Lordship, this is for the
withdrawal of their names from the writ petitions, madam, pending writ petitions, madam. Their line of appointment was something different, madam. They wanted to file a press, madam, so it filed on the, madam, they were initially appointed as, madam, Sarvasiksha Abhiyan. My lord, in fact, my lord, is pending,
Striking off.
my lord.
Who are they?
They are also in the writ petitioner, my lord, in the writ petitioner, they were initially appointed as SSA teacher, my lord. As SSA teacher, my lord, after that, my lord, that they were regularized by the, my lord, department on the application submitted by the petitioner, my lord, here in the applicants, my lord.
What the applicants?
My lord, the petitioners, among petitioners, my
How
lord,
many petitioners are there?
188 petitioner,
How many ones who-
18 numbers, my lord. By this IA, my lord, 18 numbers, my lord.
Okay, just point out. No objection.
My lord, only one point, just I want to point it out, my lord. This one of the applicant number 2, my lord. He is the person who has swear the affidavit and main writ petition. My lord, that,
What do they part of the petitions?
my lord,
So,
my lord, yeah, that part, my lord.
Mr. Efkatulan, counsel for the applicant's public petitioner by and Mr. Then stating counsel for education department for respondent member. That is stating counsel education department for respondent for opposite party public respondents. Huh?
All right,
By filing this application, the applicants who are number 1, well, person number how many institutional lots the next start of?
My lord, the writ petitioner number 1, 13, 14, 17,
14, 17,
22, 25, 140, 114, and 118, my lord.
why you want to? Why you want to pursue?
My lord, my lord, admittedly, my lord, we have stated in our applications that, my lord, we were appointed, initially appointed as SSA teacher, my lord. We wanted to continue in that post, my lord.
Want to continue?
Yes, my lord.
Not say all detail all
My lord. So therefore, my lord, only liberty to file April.
But petitioners, huh?
Yes,
Petition number 1, 13, 14, 17, 20, 21, 118.
yes.
Yeah, correct.
one observation can be made. One observation may be kindly observe. With the liberty to file a fresh matter. Fresh in as I fresh writ petition. Yes. So therefore, the leaving that scope open, may kindly observe one what. We wanted to withdraw the case, the dear's name from the list of the writ petition. With the liberty to file a fresh ipso advisement.
Why?
But
Cannot, if you want to withdraw from this case, which you don't want to pursue, same cause of action, you cannot. Take your liberty.
just
And if there is a different cause of action.
however, as we have already pointed out in our specific environment by way of specific environment, we have made that initially they were appointed as a associate teacher, just we wanted to pursue that part, so that once it is we are pursuing here for the continuation of the reinstatement of their services in the terminated post, this is separate cause of action, admittedly, but somehow connected, so therefore if it is what
See, if you don't want to pursue this,
yes,
cannot.
yes,
After allowing you to extract up from the person, we cannot allow to by the press petition and same cause of action. And if there is a different cause of action, another cause of action, no one can stop.
admittedly, then in that case,
After allowing from this petition, striking off, the ground that you don't want to pursue the same events and same cause of action cannot allow you. But you cannot.
But that is the problem, that is the same cause of action, even tomorrow if challenge also, that they may not be allowed. That is the problem.
That's why you want to withdraw from here.
here,
The same cause of action.
here, the writ petition is basically against the impune termination order,
Then,
so
if you have a different cause of action, why liberty is required?
another cause of action that is not raised, admittedly,
If it's not raised, nobody will stop.
so just keep the matter alive in raising another issue,
I think tomorrow it may problem for the petitioner,
Yes,
madam. If because if they withdraw from this petition, madam, that is their they have been terminated, madam. That were the impugn, madam. Now initially when ultimately unless that they challenge that impugn order, madam, they cannot go, madam. This subject matter the same, my lord.
yes, ma'am.
So tomorrow they will have a problem, madam.
Exactly, ma'am.
What I feel, my lord, instead of withdrawing, madam.
They should pursue it.
Yes, madam. That is madam. Otherwise, technically they will have a problem tomorrow.
Yes,
In other.
that is just
No, we cannot. We cannot give you a liberty to agitate the same cause of action, same grievance in another writ petition. This is not permissible. Am I clear?
I got
If you don't want to pursue this grievance which you have made, therefore you are filing application for a signing off.
yes, I'm very sorry,
We cannot give you a liberty to again approach this for on the same cause of action and same grievance which you have done.
in that case,
You don't want to.
My lord, in that case, my lord, this Supreme Court said that repeatedly filing same cause is amount to criminal contempt. madam. That tomorrow they will have a problem.
then may
To withdraw the, then in that
Yes.
case, you withdraw the-
Yes.
Depose your court. After the courts are what they have to. All of what we can.
since this
Somewhere a good function.
that is the this is the admittedly, this is the whole problem, we were serving in the department.
No, not that. So that's not the applicant. Yeah. Fresh for submits that we never allowed.
They've left him.
Item number 21.
My lord, in this writ petition, we have prayed that the compensation amount that has been arrived at by the deputy commissioner. Yes, my lord, that's the,
Why you are not disbursing?
No, see, I have not received the money.
Why? Who has to receive? Who has to pay?
Deputy Commissioner, of course, will disperse.
No, no, disburse, but who has to pay? With the quarrying authority.
is the BRTF.
Yeah,
Yes, with the,
BRTF is not a party.
yeah,
Union is there.
Yeah, Union of India.
yes.
Yes. I think Tata would be representing.
What is your, that's the step?
Lots of assessment project, we have said that
You have
After
done it,
the
it has been
consent-
sent it to the quarrying authority, right?
we have sent to the
What they're saying is that
secretary then manager.
it has been prepared under duress.
Yes.
That's
We
the
have said
standard.
that After constant pressure from the petition.
Well, there's a one peculiar affidavit. Individuals can pressure the authority to.
In
no.
occasion, they are doing also. It can happen.
Let us not decide.
And then we
Not
don't-
our individual knowledge.
Yes.
Father, we have said that also the question for this heading of the person, the reserve forest area. Cessa of the sanctuary and that, that, that's
It's the right answer. Whether we find that better we very simple. Okay, both the.
Yes.
And when we have okay. Right.
Yes.
But something that's so complicated. Yes, where is your affidavit? Have you found that?
Yes.
Your stand is that though you have prepared, might have been under the, right?
Yes.
say it's so.
But then they say, has it got the approval of the government? Has it been approved?
Well, we have sent it to the secretary.
It has not been approved. And also.
Respondent number 2. Notification.
Then assessment. When it was said. That was when you have said that by the last one.
2018.
18 June 2018. My election for
Yes, that is the last one.
West September.
You have said that they have asked for something and you have again re-forwarded.
Yes.
That's re-forwarded which then?
Forwarded. What was this?
You have said re-forwarded something like that. Last draft notification one.
Draft notification also.
The draft notification. At least you have said forward. Yeah. Secretary led management. Where they get, on what way?
18 June 2018.
How did they do? That's.
Last, I'm sorry, Madam.
Left of. What? Every 5 months, the 5 years.
Yes.
Then that not been.
Madam, I'm sorry to correct, that was the first letter, but last letter is 9th July 2018.
9
Yes.
That's 9 2018.
Yes, ma'am.
Consider able. That since he got directed to operate instruction. Publishing of the second, then the method will be given up the final expression on his search.
21.
Just
Yes.
get it that effect.
Also, I am told secretary has also filed a affidavit, but then not that wasn't by us, by that standing council.
Do you have received?
Yes. I'll give a copy. Nothing about that. Nothing about that one. They have simply said it's under wildlife sanctuary, that's all. The secretary has said the portion is within the wildlife sanctuary. That's the only reply.
But it is one like section 20% of the question. Cannot be paid. But it has to be.
Also say that, we have also said that this falls within the type of wildlife.
But
Then object instruction.
people reside there since centuries. Well.
It's a, object instruction. And we got the settlement of the for compensation.
Construction is already over.
But if they can show that it's also after 12 of the well, illegal, will rather be directed to having brought that
This was not the construction is from widely or
yes,
from too late important.
Obliged.
Item number 22.
It's matter pertaining to the tender of calling off the transportation contract for
transport the petition.
cities.
For the
I am for the, yes, ma'am.
or you end up in there, are you in there? I mean, maybe because of possibility. It's okay. It's application very simple. Your rejection is that the S enterprises S is omitted.
No, that was
What I have seen.
no, that is not. That was clear.
Okay, this was not on that.
Not on. That was clear ultimately. They have cancelled it now, saying that my prices have normally low. How I don't know. So I think
Normally
that-
high.
No, low. Abnormally high. How can it be abnormally high? I have bid at 44 lakhs less. The estimate was put together.
What is the cost? I just glanced through yesterday. I said, if this is again direct immediate dispose of the matter, that is not a case.
That was correct. I have been trying to take up now.
Okay.
I think sometime.
Next. My lord, stayed in February, but the public of Arunachal Pradesh will suffer, my lord, because now and contract has also been.
Who is supplying?
I'm supplying on it.
Like that now that has been expired, my lord. That ad hoc contract has also been.
You radio it.
Now we are
You radio it because
my lord,
today
next Thursday, my lord.
we were ready, but then problem.
Yes, paucity of time, my lord. Tomorrow or then next Thursday, my lord. Next Thursday, my lord. That is on 28th.
Forward patterns. That is your thought.
Yes,
Again, again, the bank website.
28th, my
To
lord.
have a better.
Do it.
property.
28th.
Wait,
28th, my lord.
28.
28th of this
Wait.
month. Yes, ma'am. 28th. Today is 19th. Next Thursday, ma'am.
Wait,
28th.
not 20.
Not 20. 20.
Which possible that. That's
FCA. Obliged.